লিখুন। Kolkata Municipal Corporation and
Yes, same question.
Municipal Corporation and others. It has been submitted that the result of the present writ petition hinges on the result of the two other writ petitions that have been filed by the petitioners as aforesaid, where the orders of demolition passed by the Kolkata Municipal Corporation.
Is it going as my submission?
That was your submission.
That was what you managed is indicated on the other day based on that. That's not what I would deepest to humility. That's not what I feel. I feel that there is a scope of interim order. These two are obviously connected. It's between the same parties, between the same property.
No. Scope of interim order would mean that I am giving you final relief at this stage without entering into the question of.
That's the findings of the court. Will I bow down to that? Let us not go down as my submission.
Very well. No, but it was your submission.
But yesterday, I've indicated yesterday that this is the situation. Milord was having a view that since that 412A is that the order is staring at our face, we are not.
Then I'm recording that submission of yours. It has to be on somebody's.
Yes,
submission, not releasing.
Well, I say that because there was a finding of the court.
Mr. Ganguly submits that since on the last occasion, the court, this court had opined that the condition of the building is an important aspect which would be required to be kept in mind and considered for passing any order for resumption of supply on the writ petition, and therefore Kolkata Municipal Corporation was necessarily required to be heard, therefore now since this was the finding, therefore that I can.
Therefore, we have after that finding, we have challenged that 412A order before the coordinate bench of this court, and I'm informing this to the court. The court feels that this should matters be taken up by the same bench. This relates to the same property, and this is dependent. Well, I understand this is dependent from that order. Hence, it may
different, lordship. Is it regarding
It is his submission. He wants it to go. Let it go.
My lord, may I representing respondent number 8 and 9, my lord? Respondent number 8 and 9. The actual fact is that they are aware about the no, order of the
Please
400.
wait. Please wait. Therefore, it would be proper if the same court that all the matters are heard by the same court. Full stop. In such view of the matter, this writ petition is this matter stands released from this list to be placed before the Honorable the Acting Chief Justice for appropriate orders. Okay.
My lord, may I request my presence may be noted.
Yes, give your presence. It will be recorded. Mr. Ganguly,
I'm very sorry,
whenever
kindly take me amiss, I'm very sorry.
you
But we appear on behalf
I
of
am
the
for WBS.
writ petitioner, my lord. I am for the writ petitioner, my lord.
Yes.
A complaint was lodged in the Kharagpur local police station about the theft of electricity under section 135 of the Electricity Act. My lord, against that, my lord, the provisional assessment bill as well as final assessment was challenged by the petitioner by preferring an appeal. Now, ultimately, my lord, this theft of charges were not proved. Petitioner was acquitted and my lord, released from the case. And thereafter, my lord, the petitioner applied for refund of the entire money under the final assessment order bill as well as compensation and litigation cost. If my lord, this was the claim, my lord. Complaint, my lord, at page 18 and 19, annexure P1, complaint. Order of acquittal at page 34, 35.
Yes, Mr. Dr. Sahara.
Hi, Lordship, this is no more race intrigue. Your Lordship knows. So far, the final order of assessment has been passed in 2004. And there is no privity of contract with the petitioner.
Who is the petitioner?
The petitioner is Proloy Rai. The main original consumer is the Mrityunjoy Rai. And 2004 final order of assessment passed. No appeal has been preferred against that order.
Appeal was
They have paid that amount, and on that basis, and your Lordship knows, then the mere acquittal does not ipso facto entail them to accrue the right that they are entitled to get payment. A Lordship knows that in similar circumstances, your Lordship has passed this order.
in order to prefer appeal, I am to pay 1/3 of the bill. Thereafter, full payment was made.
1/3.
But ultimately, my lord, petitioner was acquitted. Charges of theft could not be proved by the prosecution.
But how will you distinguish between civil liability and criminal liability? The standard of proof is different for both.
My lord,
So far as
let them use affidavit. My lord, I will deal with each paragraph.
no use. There is no use. File a short affidavit, Dr. Sahara.
My Lordship knows there is no use because in the similar circumstances, your Lordship has passed this order. I don't want to waste the time of this.
Serve a copy of that order to him. Let him
Yes,
consider
certainly. Certainly.
Take this, consider and come back.
Then I will put it on affidavit, subject to your Lordship. If your Lordship direct me, because your Lordship is also well aware, this is no more race intrigue. Two proceedings are absolutely on a different footing. One is
And how is the petitioner related to the
the petitioner related to the son, father and son. Like this matter, husband and wife. This is also similar. That was in 2009 and in 2014. Lordship kindly appreciate this acquittal order has been passed. No one can sit over his own right, Lordship. And Lordship kindly see the representation they have given.
Petitioner
In
was suffering for a
2015.
long period.
2015.
Petitioner was suffering for a prolonged period, my lord.
But that is not the criteria. In
I-
2015,
I
there is no
produced-
receipt of that notice.
Treatment papers I
Let
have
them
produced.
furnish the document. We haven't received in 2014 that notice.
I have annexed the treatment papers, entire treatment papers, my lord.
But even the money claim, your lordship knows, under the Limitation Act, it is barred. But I am not on going into because it is no more res intriga. So far, the proceeding is concerned, civil liability and criminal liability. Series of decision passed by this court, by the single bench as well as division bench. Even the Supreme Court also has specified that this is absolutely on a different footing.
Let me deal with the allegation of points of law raised by my friend.
Already one order has been passed, lordship.
In similar cases, I have passed one order.
Yes.
Give a copy
Yes,
to
yes.
him. Please go through it. It's a similar case. I'm making it not today. It will appear again day after tomorrow.
No.
I mean on Monday. लिखे नहीं. The petitioner.
That I appear on behalf of WBSCTCL.
I'm for the petitioner, man.
And I will
Right.
kindly come to page number 8, paragraph A, prayer A. Achha.
But service has not been affected upon the private respondent.
I would like to file a report to this.
You want disconnection of somebody's life?
But petitioner is the owner of the land. But the licensee, my lord, has drawn electric connection over the land of the petitioner without any consent, my lord.
So we want to file a report, Manoj.
Conduct inspection, file a report. Who is the private respondent?
But I have sent, my lord, service has not been affected.
Then लिखे नहीं.
Manoj, my
Uh,
junior is
In my lord, I am appearing on behalf of the petitioner, my lord. My lord, service upon the private respondent, my lord.
के दिलो और समर बाबू दिलो ना.
my lord, in the forwarding letter, I have informed that the matter will appear on 6th. If your lordship kindly take up.
My lord, in this matters. Affidavit
for the
my
financial
affidavit of service, my lord. My lord, it is my petition, my lord. This is my affidavit of service, my lord. Actually, respondent number 5, 6, and 7, my lord. Instead of taking possession on respondent number 11, my lord, they are taking possession of the flat owners. We are not at all have received any 13.3 or 13.4 in connection with the matter, my lord. We are the simple, our status is flat owners. We are not in dispute with the matter, my lord. My lord, I am only praying before you, my lord, to stay the order of the district magistrate in terms in accordance with the, my lord, prayer 2 and 3 of the annexure, my lord, prayer P2 and P3, order of the district magistrate. At least for 4 weeks. In the meantime, we shall go to DRT to fight against the.
We can't stay.
My lord, we are not the borrower or not the guarantors, my lord.
We are restrained by the state respondent.
State respondents, my lord, to end
The
DRT,
bracket
my lord.
process will be done on 4th of
4th of
August.
August, my lord, on
on
Tuesday, my lord.
I appear for the financial institution, Lordship. I have a point of maintainability firstly, and secondly, Lordship kindly sees page 23 of the petition, Lordship. This is the undertaking given by the petitioner that they have wanted. They asked for at least 15 days time to resolve the dispute between the parties. It is their undertaking only. Kindly, Lordship sees page 23.
They have forced.
Two of you can't argue. I decide amongst yourself who will argue. That is not the way. Who is he?
Lordship, as so far as my instruction goes, he is the tenant of the property, Lordship, and the borrower are the respondent number 11 and 10 and 11.
What is your claim in the property? Who are you in the property?
My lord, we are the land.
Please wait, sir. Are you going to argue or he is going to argue? Then you
My lord,
yes.
we are the flat owners, my lord. We are not the landowners or not the developers, my lord. Actually, loan was taken by the landowner. We are not at all attached with them, my lord. We have simply flat owners. We have been, they have, instead of serving notice upon them, they have served notice upon them. Me ask the petitioners to take over our possession of the flats. My lord, this is my humble submission, my lord, to cause or stay the operation of the P2 and P3, annexure in annexure P2 and P3, and allow us to.
Who is the Cholamandalam?
Lordship,
The financial institution is Cholamandalam.
Cholamandalam, Lordship.
When was this order passed?
This was
We-
passed on 12th
we are the-
May 2026. Lordship.
We have
When are
only
you
we have our deeds, my lord, all of us.
When are you going to execute?
3rd of January 2025 is the district magistrate's order, Lordship. Thereafter, there was the notice for vacating of the property. It was served on the petitioner on 14th of July, and we visited the property on 21st of July for taking possession. When they have requested for a certain period of time so that they can resolve the dispute between the parties and clear the outstanding dues, and that 15 days time was given, and that is going to expire on 4th of August, Lordship.
So 4th August, if you have time, you can approach the DRT on Monday.
Gotcha.
What is the problem?
My lord, we
and give it.
kindly restrain the order of the DM.
You could
Otherwise,
get
my lord,
You can
how
get
shall I
this.
go before the DRT, my lord, unless it is not
Why will
restrained?
you not go before?
My lord, kindly allow us at least 2 weeks time, and in the meantime, we shall go to the district magistrate, my lord. Kindly come to the grounds
You
of the.
cannot go to the district magistrate. District magistrate has no power under the surface.
Very good, my lord. We have not in touch with the notice, my lord, in connection with the matter, because we
You
have
are aggrieved
we
with
have
this.
we have
You are aggrieved with this.
yes,
section
I have
14 notice.
agreed with the notice in because they have forcefully come us to take
Very
our
well,
position.
that is assailable before the DRT. You have to approach DRT only. High Court cannot come and protect you.
Very good, my lord. I shall appreciate you, my lord. My lord, kindly allow us 2 weeks time to
Under
go.
what law I will allow you 2 weeks time?
My
Under
lord, can I
which law?
submit one
Please
flag, my
read.
lord?
Please read the judgment of Rungta, AIR 1952 Supreme Court. If I am sending you back to the alternative forum, I cannot pass any order of stay, and that has been reiterated by the Honorable Supreme Court as late as in February 2026. That is not the law. That if I redirect you to DRT, I will pass an interim stay in the meantime. That's not the law.
My lord, unless you, my lord, kindly come to the grounds, my lord. Page number 9, from page number 9, my lord. Paragraph 1, 2, 3, and paragraph 5, my lord. Kindly see the grounds, my lord. Unless it is not stayed at least for 2 weeks, how could I go to DRT,
This
my lord?
argument will not help.
If my possession is going to go has been exhausted, my lord, what is
So
the need for
why
going
did you
to
not
DRT?
go to DRT for all these 15 days for which you gave this?
But regular, my lord, regular POs in DRT on leave. Therefore, I have come before you to take the.
Regular PO is on leave. There is also a PO in charge.
I shall come before you to take.
Move before the PO in charge, who is
Take
who
at
is
least
there.
2 weeks time to go before the appropriate
already
bench,
have 2
unless it
weeks
is
time.
not. It is not.
21st, you
My
have.
lord, kindly, if you not allow me at least for 2 weeks, my lord, I shall. How could I go to the DRT to file the appropriate?
This argument has.
My lord, kindly at least give us 2 weeks time to go to the DRT, and in the meantime, my lord, destined the notice of the DM, my lord. But that we are not binding at all with the notice, my lord.
You are bound.
According to 13.4, we have already 45 doses available before us, but unless it is not restrained, my lord, how could I go to
the place where the order is to be executed?
Horisabha Lane, Baripur.
The forward has a flat on that premises.
You all are residing
They
there.
can seal that.
You are residing there, my lord.
What is the address that you have given in the cost title? All of you have given different addresses in the cost title.
Yes, my lord. Yes, my lord. We are all living there.
Kindly before petitioners, my lord.
Actually, they are petitioners at 1 to 8, my lord. We are all living there.
Last, my lord.
You have 2 residences then. What is your problem? You have given your residence, and now for the purpose of this writ petition, you are residing there.
No, we actually residing there, my lord.
We are residing there, my lord.
We have our respective deeds.
You have given other addresses also. If you are residing there,
We are residing there, my lord.
Actually, my other address, my lord.
You are not required to give 4 addresses. The first address that you have given is your address, and then you are also residing there.
We are residing there, my lord.
My lord, kindly look at annexure P3, my lord.
Yes, P3.
They have no locus standi or that land, my lord. The land trial court have rejected to pass the interlocutory order, my lord.
Argue before the DRT. Argue that.
My lord, that is the reason, my lord, I am praying before you at least allow us 2 weeks time to go to DRT, my lord.
You cannot allow 2 weeks time at your whim merely because you ask for.
Otherwise, we shall throw into the street, my lord, unless you are not.
My lord, kindly see page 23, my lord. It was their undertaking only. If they fail to do so, we will peacefully hand over the physical possession of our flat to the authorized officer of the captioned bank.
Because we are signed coercively, my lord.
We have forcefully.
There was no seal.
There was no seal, my lord. That was forcefully
On the next page,
signed before me
the signature
to us, my lord.
flat owners given.
And they told us to pay 1 lakh each to the bank. My lord, how can servicing action bind with us? This is a violation of section 128 of Indian Contract Act, my lord.
They are forcefully written that statement to us, my lord. As they have not put there any signatures, any seal there on, my lord.
You approach the DRT.
We shall approach DRT, my lord.
My lord,
According to which,
my lord.
we must approach DRT, my lord. In the
Time
meantime,
to pass,
kindly give us a reasonable time, my lord. We shall go to DRT in the
and pass
meantime
an order.
and
The
thereafter 13-4 on August 2024.
5 dates, my lord.
Lordship, if it is a dispute of the ownership, Lordship, then the REIT court doesn't have jurisdiction to adjudicate this.
jurisdiction I have. You can't say I don't have
Jurisdiction.
whether I will exercise discretion or not is the question.
Lordship,
It's not a question of lack of jurisdiction. It's a question of will to exercise discretion. Writ petition is always maintainable. Whether it is entertainable or not is a question.
Lordship, in the third paragraph of the section 14
বলিস না,
Lordship,
সবাই মিলে বলিস না, বুঝতে
the
পেরেছিস?
mortgage
কেটে যাবে আবার।
2019 documents and status report submitted by the authorized officer, it transfers that secured creditor granted a loan of rupees 48,90,000 on 27th May 2019, 19th July 2019, and 30 August 2020.
Yes.
My lord, may I allow to submit something?
What is this that you handed up?
This is a deed of gift which is actually mortgaged. Now, this is have a past history. This deed is void in nature, my lord. Because of this heirship certificate.
That I cannot decide.
Yes,
This
yes,
deed
it
is
can be
void or
decided.
not, all those submissions don't make. Make submissions which make sense here. Whether
Now-
this deed is void or not, it cannot be decided by the writ court.
Yes. Now, if you allow me to show our respective deeds, we can show you that, my lord.
Either show me your deed.
And my lord, this project is approved further in State Bank of India, my lord. This Udayan project,
Not there. You can take all
all
these
the
points.
deeds.
When you had executed the undertaking on 21st of July, what were you doing all these days? Why did you not challenge it before the DRT?
My lord,
But they are
because,
not at all
because there are technical glitches in DRT code
There
paying
is no
server, my
technical
lord.
glitches in DRT. You could have approached for 15 days, there were technical glitches. You mean to say that for these 15 days, no matter was filed in DRT?
My lord,
What of submission are you making?
my lord,
I don't have an idea of DRT.
no,
I
no,
was
my
also
lord.
there at one point of time.
I know, my lord.
Then therefore don't make these submissions which don't cut ice at all.
My lord,
Not
they actually
satisfactory.
received the
For
notice on
15 days, there was
17th
a
of
glitch.
August, my lord.
Huh?
They actually received the notice on 17th of July, my lord.
Sir, your undertaking is 17th of July. Let us give a go by. I am
have
going by
forcefully
your
taken
undertaking on
undertaking
21st of July. From 21st of July till 31st of July, 10 days have gone. Now another 4 days will go. Why did you waste time of your clients by bringing them here? You could have always approached the DRT, obtained an interim order there. By this time, you could have got an interim order if you had a case. But you wanted to take an easy way. Why did you mislead your clients to come over here in the
Because,
High
my
Court?
lord, my Cholamandalam Finance deliberately called me and telling we will take your possession on tomorrow, my lord.
Yes, so they will do that if you don't take steps after giving undertaking, you say that yes, in 15 days we'll
But
find a
we are
resolution.
not
You could have
taking
approached the DRT with that 15 days. Now you have wasted all the time. When the date is ripe, you come before the High Court and you want another 15 days to go before the DRT again. How does it make any sense?
My lord, we have 45 days limitation, my lord.
So you could have approached 45 days limitation. Go and approach there. Who is stopping your
Very good,
limitation?
my lord.
I'm not curtailing your limitation.
meantime, restrain them for taking possession in the
One
meantime.
of you speak.
My lord.
He's speaking now. Now, please. Yes.
My lord, only restrain them to do not take
How
possession in
foolish.
court
It's
of my
not,
lord.
it's not a matter of joke that I will pass a restraint order on anybody merely because you want it. You show me the law that I can do it while sending you to the DRT.
My
Show
lord,
me
at
that law.
least give me the scope of natural justice,
Please.
my lord.
Natural justice you'll get before the DRT. You had natural justice for all these 15 days, 14 days. You wrote a undertaking on yourself saying that yes, I will take steps within 15 days. You don't go to DRT. You waste 10 days. On the 10th day, you approach the High Court by filing a writ petition. How do you justify this conduct? You tell me. How do you justify?
My lord, they are not written anything, my lord. That was written by the executive magistrate and they are signed, my lord.
No, that I cannot take. You have signed, you have annexed it to your writ petition. This is
You
your
kindly see
annexure.
that
This is
they
not
are
their
also seal
document.
of executive magistrate, my lord.
This is your document. This document at page 23
They
is
have
your
forcefully
document.
taken the
They
signature.
are forcefully taken
Forcefully
the
or not,
signature by
If
offering
it
our
was
flats, my
forcefully,
lord.
if it was forcefully done, you could have approached the police authorities, lodged a criminal complaint saying that they have forcefully got a document executed. You simply cannot barge in before the writ court and say, stay all the proceedings. I will approach the DRT at my will. That is not the law.
We have filed a complaint against the borrower, my lord, actually.
That is up to you against whom you file. If you don't take the right action, you take the wrong action. You cannot come before the High Court saying that no, this has happened. Now you allow 14 days time to me again. What for will you get for 14 days? If I stay, what will you do? You'll again approach DRT. Why don't approach today? Go and approach today. DRT is open. Today it is open. On Monday it will be open. Till 4th, they will not take any step in any case. You have 3 more days. You are wasting time. Already it is 11:33.
Then,
You
my
have
lord, allow
by
me
2
some
PM
day to
filing.
serving them all the DRT petitions, my lord, at least. Allow me some time to serve them the DRT petitions, my lord. They are
You have
my case,
time.
they are signed.
You have time. You have time. File it today. Till 4th, they are not going to do anything. They will not do till 4th. That is what you have also said. That is
Okay,
your
my lord.
submission also. Till 4th, they have granted you time. File it, move it before the DRT by 4th. Take interim order.
Okay, my lord.
Your submission. Then
I will serve them within Monday, my lord.
whatever you do, serve them by Monday. By
Lord, in the
today, you are
meantime,
free. You take this back. দিয়ে দিন Once I say that you have to approach DRT, I cannot in the same breath say that I will stay the proceedings. No interim order can be passed. If I am directing you to the alternative forum, it has to be with the alternative forum only. लिखे नहीं.
My lord, at least allow us only 7 days of time to at least file the stay petition before DRT, my lord.
My lord,
Madam,
at
can
7 days.
wait. Can you postpone that date from?
My lord, before lordship humble submission, my lord, at CL number 11, I am for Union of India, Sukanta Banerjee, my lord.
Yes, what happened?
I'm for Union of India at CL number 11, in the matter of Soikot Haldar, my lord. If is the matter, my name may be kept on
Very
record.
Yes.
Lordship,
Maybe
so far
of
as
my-
my action goes,
I've understood. You want your name to be recorded. I have understood.
in
Yes.
21st of July, we went for taking possession, and on humanitarian ground, we have given them 15 days time, which is going to expire on 4th of August. That is what my instruction is, Lordship.
Till 4th you have time.
My lord, allow me the
Already-
only statutory time, my lord.
already
That is a
statutory
gratifying
Time.
aspect.
What more statutory time?
45 days, my lord.
That is
45 days from now? No. You have
7 days.
Not from
now.
today, my lord. Calculated from 14/7/2026.
So then why did you write 15 days there? Unnecessarily, I cannot go on
That is
extending.
already
Only
done.
7 days time.
I will give you opportunity to make a representation before them. If you can convince them for some more time, they will agree to it. File it in the meantime.
Okay, my lord.
My lord, kindly allow us only.
This is running.
only
That is
7
already
days time.
continuing. It is not that it has been expired if
Okay.
they are saying that they have the knowledge from today.
This writ petition assails
Only 7 days, my lord.
the to the merits of their claim, your claim. All
And then certified copy in course of duty, my lord.
certified copy you will not get. You will get server
Xerox certified copy, my lord.
server copy.
Very good. Server
good.
copy, my lord, in
Yes.
course of duty. Deeply obliged.
I am for the petitioner in this matter, my lord. My lord, the service upon the private respondents 3, 4, and 5 is not complete, my lord.
I am for the state, my lord.
Next. Yeah.
My lord, I am appearing in person. This application is for the expeditious disposal of the diary number 1129 of 2025 and IAA number 2616 of 2025 filed with the DRT.
Who is appearing for the bank?
Expeditious disposal.
Even then, who is this is a writ petition? Who is appearing for the bank? Serve the bank and come. The petitioner.
For expeditious disposal.
Serve the bank and come, sir. Petitioner shall serve a copy of this writ application upon the respondent numbers 1 and 2. And file affidavit of service on the returnable date. List this matter. How soon can you serve?
By register post.
How soon? How long will you take to serve?
Within 7 days.
List this matter after a week. Next. Fourteen.
15. They are different matter.
What is there in 14?
14 essay, I am filed essay in 2022, still pending with SRAD.
Same order. Same order after a week. Serve in the meantime. Please serve.
Okay, my lord.
Yes,
Expeditious disposal, there is no harm to any group.
No. This writ petition, I will not dispose like that. There are other persons also. Yes.
Item number 15, my lord, I am the petitioner in person in the matter. This is the service. My lord, the case of your petitioner is that your petitioner is the legal heir of the consumer of CSC Limited, and CSC Limited, they have disconnected the supply due to due to outstanding dues in the month of November 2024. And thereafter, your petitioner has applied for reconnection of the electricity, and the consumer of the CSC Limited, he has given the NOC for name change. And I have made the application in the month of October 2025. Thereafter, I have made written representation seeking expeditious issuance of the reconnection bill, but they have denied the production of the bill. So constantly without electricity due to the not production of the bill, I was suffering.
I haven't got the copy. Just
Yes,
now.
sir.
Just told that lordship.
No, yes, sir. Delivered.
My lord, the prayer is just that the
We consider subject to lordship kind approval if it is possible.
my lord, the
It seems that they have made a representations at page 34. Page 34.
my lord, may I?
Kindly,
There are outstanding dues.
I am ready to clear that, but that today only I will clear it.
if they are ready
My
to
lord,
pay that.
The only grievance is that there is some electrical discharge, some tampering is there. I have made,
May I
I have
submit
made,
one
I have communicated in writing that there is some electrical wiring, some problem is there. So I have requested that please engage some personnel who is licensed personnel to inspect the premises, but they have neglected that also. And constantly a high exorbitant bill is being issued, and that the consumer of your consumer is a retired employee and he's not able to pay the dues. So he has given authorization to me to pay the outstanding dues, but they have added the security deposit amount also. That I am aggrieved. I want to pay in a installment, that security amount. I am ready to pay the outstanding dues.
Mr. Dr. Saharai, he says that he will pay the outstanding. So far as security deposit is concerned, he needs some installments. He will pay that.
May I submit one thing subject to, just now I have given from this document what I gather, lordship, subject to lordship kind approval. May I submit lordship that we have to make an inspection whether there is any LCC due or not. But at present, at this moment, I cannot specify before lordship, subject to lordship kind approval. If your lordship kindly allow us, if your lordship kindly allow us to keep this matter, even if you want to, then the second half, then I will take the instruction and come back before your lordship.
Consolidated bill has already been issued, and there it is given the outstanding amount is there already, they have declared. I am supposed to pay the outstanding amount, and they are supposed to effect the electricity on payment.
Tampering or not, that has to be.
That the inspection can be made afterwards also. There is no dispute in that. If there is some tampering, they can engage any licensed authority for inspection.
If there is tampering, then that is unauthorized. Then that will be.
But the tampering is the consumer is not has done any tampering, but some. But I am living without electricity for so much
kindly
time.
keep it up. Keep this matter on Tuesday, subject to lordship. And
Lord,
take the concrete instruction and come back before your lordship.
Your petitioner is without electricity for 1.5 years, and your petitioner is giving the premises to rent.
For 1.5 years, 2 more days will not.
No, my lord. The mean
in the meantime, they can conduct an inspection.
Yes.
Ma'am, I'm ready to pay the outstanding dues. The only grievance is that the security deposit be considered for the peer.
Very well, but let them have an inspection there. Why are you?
My lord, my only grievance is let the electricity be connection be given, effected.
Without having an inspection, it has been lying disconnected for 1.5 years.
Yes, yes.
Without looking at the.
But my lord, your lordship should consider the fact that after forwarding so many communicating so many letters, they have not taken steps. It is their fault.
They will take.
But I am, as a bona fide person, I am ready to pay the outstanding dues for electing.
Take steps. They will go for inspection.
No, today itself, my lordship can direct today itself. I am ready to pay today itself. But the fact is that without electricity.
Try to understand. There has to be an inspection first.
Yes.
1.5 years it has been lying dormant.
Yes.
Without an inspection, I cannot direct reconnection without them first coming and telling that upon inspection they have found everything in order. That has to be seen. Merely because you come and say after 1.5 years, give me connection, I will grant that. That is not the way. You have waited for so long.
But they have not given me any communication that I will.
Directing now.
Yes.
For inspection.
But a very short span of time, my lord. That I'm.
Tuesday is the date that we are fixing. What short than that? Can you come
on that day, kindly lordship directs. Because the fact is only that your petitioner is renting the premises to some person, and he is giving some money, and with that money, I'm getting the.
That is your business interest. For that, you cannot suddenly come. Now your urgency has arisen because you want to rent it out. Therefore, you want the court to.
No, I'm paying the outstanding dues from the rent.
So what?
And your petitioner is living without electricity for a long span of time.
Yes. So
and
now,
they have
now because a long span of time it has been living. Now you have come.
But they have neglected the representation.
And you have also come up to court now after 1.5 years. You want the order now without the court following the process of inspection.
Yes, your lordship kindly follows.
Why are you unnecessarily wasting time?
As your lordship directs.
লিখে
একটু দেখে নি শুনি দেখে নি
ঠিক আছে this writ petition alleges
instruction on that.
Come back in 5 minutes.
My item number is 22, 23. And I understand, my lord, there are so many fixed matters before your lordship, my lord.
Your, who is your other side? Mr. Chakraborty was appearing.
Yes. So may I inform him, my lord, may I come back at 2? Obviously.
May it please your lordship, my lord.
I would have preferred a short passover, but since it's his writ petition, he may place it. I shall take notes because Mr. Shandal is on legs in our before division bench.
Respondent number 4.
May I place the affidavit in reply, my lord? My lord, to refresh your lordship's memory, affidavit in Now, my lord, to refresh your lordship's memory, here a television channel was running from Poddar Court. Now, my lord, the channel, the tenancy was at 6th floor, having near about 16,000 square feet. Now, my lord, initially the landlord, the private respondent, used to give electricity to me, and thereafter that was disconnected in the month of June, end of June. Now, my lord, after that, we applied for electricity. Now, my lord, the electricity was rejected. The application was not considered and it was rejected on the ground that as there is, my lord, one HT supply is in existence, my lord, LT supply cannot be provided to it. Now, my lord, to cut short the matter, they have filed an affidavit. Now, my lord, the affidavit, my lord, lordship, they have urged 2 legal points, and 1 point, the second point is mixed with the facts. The first point that they have urged is, my lord, for electricity connection to be given, a premises has to be taken as, my lord, the consumer and not the unit. This is the first one. And second one is, my lord, that HT and LT, there will be security problem, there can be hazard. But, my lord, interestingly, my lord, no inspection report has been filed with the affidavit in opposition. There is no inspection report, and the statements made in the affidavit in opposition are in general in nature. They have not clarified how it is going to create hazard. Now, my lord, I am going to answer the first point first, and then, my lord, I will take your lordship to the second point. The first point is, my lord, that a premises to be taken as the consumer. Now, my lord, when I was reading or deliberating over this case, I was quite amused by this first point. My lord, the electricity right to get electricity is, my lord, a statutory right, and at the same time, it's a fundamental right. So, my lord, the statutory and fundamental right cannot be given to, my lord, a premises. It has to be given to, my lord, the occupier who are in settled possession. In a premises, there can be 100, there can be 5, there can be any number. But each and everyone has statutory right as well as, my lord, the right, fundamental right. Now, my lord, here, I am not going to waste your lordship's time by, my lord, placing the sections of the Electricity Act. On the contrary, I will take your lordship to a judgment of Supreme Court which settles the issue. Now, the judgment reported in 2023 volume 14 SCC 431. May I hand over a copy?
2023
volume 14 SCC 431. My lord, 3 judges bench of Supreme Court. My lord, first,
this was on the charge and all dues and
yes, but it has been decided. It has been decided. My lord, straightway, my lord, kindly come to paragraph 30. I'm not going to place, my lord, the sections 43 or, my lord, because it is there, my lord. There is no issue, my lord, rather than wasting your lordship's precious time. Kindly come to paragraph 30. Section, may I place it, my lord? Section 43 of the 2000 Act is similar to section 22 of the 1910 Act
read with clause 6 of Schedule 1 of the latter Act. Part 6 of 2003 Act contains provision dealing with distribution of electricity by distribution licenses. Section 270 defines distribution licensee as a licensee authorized to operate and maintain a distribution system for supplying electricity to the consumer in the area of supply. Section 43 of 2003 Act cast a duty on every distribution licensee to supply electricity to the premises on an application made by the owner or occupier of such premises. The provision requires distribution licensee to lay down its network in a particular area to supply electricity to a consumer who demands supply. So it's not premises. Then, my lord, kindly skip the section 43 and come to, my lord, please come to paragraph 32. Section 43, the distribution licensee is obligated to supply electricity to the premises of an owner or occupier within month of receipt of an application requiring such supply. The provision casts a duty on the distribution licensee to supply electricity to the owner or occupier of the premises. Correspondingly, the owner or occupier of the premises has a right to apply and obtain electric supply from the distribution licensee. Both the right corresponding duty are imposed by the statute. The owner or occupier of the premises has to submit an application. So this is, my lord. Then kindly come to 36. Section 47 indicates that a distribution licensee can refuse to supply electricity under section 4 if the applicant fails to furnish the requisite security. Under 48, a distribution licensee may require applicant who requires supply to accept any restriction which may be imposed for the purpose of enabling the supply. And with regulation under section 53, any terms of restricting liability of distribution licensee for economic loss suffering, thus the implicit distribution licensee may give electricity to the applicant until they accept such terms and restrictions reasonably imposed. So this is, my lord, I say, my lord, that the issue is, my lord, taken care of. And then, my lord, kindly come to paragraph 52. The definition of supply specifically states supply means the sale of electricity to a consumer. The said definition does not indicate the supply of electricity vis-a-vis to the premises of the consumer. Considering the overall scheme of the 2003 Act, supply of electricity is to the customer and not the premises. So this, my lord, in conclusively, my lord, Supreme Court says that. And second, my lord, 53 section 43 Act obligates distribution license to supply electricity on an application to owner. Under the provision, the right to obtain electricity supply is vested with the owner or occupier of the premises. Invariably, such occupier means a consumer under 215 as held in such and such. The duty of supply electricity comes to play only an application made by the owner or occupier of the premises. Hence, the term premises has to be contextually and understood with the respect of the preceding portion, that is, the owner or occupier of the premises. The duty of supply electricity is only with respect to the owner or occupier of the premises and not the premises, as it is the owner occupier who has the statutory right to demand electricity for the premises under the use or occupation. Further, it is the applicant who has to fulfill all statutory conditions laid down in 2000 to become entitled to get supply. The applicant has to pay necessary charges and comply with all terms and conditions determined in the such and such. So, my lord, this now, my lord, kindly come to the conclusion of this judgment, which is, my lord, 342. The duty, may I place in, my lord?
Just
342. The conclusion. Now, my lord, the judgments comes in a form of book. My lord, it starts with index, then, my lord, fact, list of
You were
dates.
reading page 491.
Conclusion.
Page 342. What are you reading?
144. My lord, second last page. second last.
Paragraph, not page.
Oh, I'm sorry, my lord. After 341, my lord. After, my lord, lordships, got it, my lord?
41.
575.
341. Yes. 574.
সেটা বললেই তো পারিস আমার তো এখানে তো well, kindly two paragraphs of the conclusion. The duty to supply electricity under section 43 of the act is not absolute, is subject to such charges and compliance stipulated by the electric utilities as part of the application for supply of electricity. The duty to supply electricity under section 43 is with respect to the owner or occupier of the premises. The 2003 Act contemplates a synergy between the consumer and the premises. Under section 43, when electricity is supplied, the owner or occupier becomes a consumer only with respect to those particular premises for which electricity is sought and provided by the electric. So I don't have to deliberate on this issue anymore on their first point. Now, the second point they say that see, HT connection, if given, LT cannot be given. Now, my lord, here, first, my lord, there was a judgment passed by single bench that was not accepted by the coordinate bench, and that went to, my lord, special bench. And special bench says, no, it has to be given. So, my lord, first I am placing the single bench judgment and...
No, please the special bench. Why unnecessarily?
Oh, lordship. Then, my lord, kindly take the Bhaskar it's unreported. I could not find the report. Let kindly have. I will hand over a copy to my other sites. আর স্টেটের হয়ে আছো আমি কি করবো বলো আর কপি নেই এখন সকালবেলা পাওয়া গেল let kindly see my learned friend was there in this matter.
Yes.
I have to place it in entirety, most of it, because there is no paragraph marking also. So I have to place it in entirety, but not a very longish judgment. The matter has been referred. Kindly, just 1 minute before I have to depart once, from this judgment. Nobin Agarwal, the judgment, which was passed by the single bench, it was in respect of a vast plot of land. So the question cropped up, the CSC took the point. Now see, LT connect, there is HT connection, and there are many tenants. So I cannot give LT connection.
Nobin Agarwal said you have to give.
You have to give. So then, the subsequent coordinate bench differ, and now this. Now kindly see, this judgment, this matter has been referred to this bench by the Honorable Chief Justice to answer the following reference: whether it is legally plausible for the CESC Limited to give a separate domestic connection from separate electric meter boards in respect of same premises which owned by different parties and not partitioned by meets and bounds as per law, either by any registered deed of partition. The fact discerned from the order such and such passed in such and such by a single bench that co-owner of the property applied for separate independent electric connection in the joint premises, and the CSC refused to accede to such prayer as an objection was raised by the co-owner. The objector, that is the other owner, relied on a judgment on such and such on the proposition that the occupiers of segregated building or structures are entitled to separate electricity connection from different meters even when there is no formal partition. Apropos to the aforesaid judgment, it was contended that in the event co-owner intends to have a separate electric connection, the same can be given through a separate electric meter installed on the same electric meter board setup for catering supply at the said premises, and therefore no separate electric line can be provided to such co-owner in respect of joint premises. The single bench ultimately held the judgment referred in Nobin Agarwal relates to a situation where high tension connection was given to cut a supply of larger premises in the event the premises is segregated physically, no partition is effected, and the same cannot be construed in case of joint premises unless the portion is effected, separate electric connection can be provided. Since the single bench could not pursue itself to agree with the ratio order laid down in the above decision, refer the matter to Honorable Chief Justice, formulating the point of reference as indicated in the first paragraph, we invited the parties to address us on such and such. The parties are at variance on factual aspect concerning the status of the property to be joint. According to the objector, the co-owner, joint property has partitioned by misowner and no longer exists a joint property. On the other hand, writ petitioner contended there has been no partition, therefore it remained as joint property. The bench cannot go into such disputed as the same is required to be determined the such and such. Now, my lord, this is very important. Interestingly, Mr. Sannal, the learned advocate appearing for the CSC, did not unequivocal terms discarded the notion of non-supply of electricity to separate electric connection in joint premises, but reserved his argument to the effect that such supply may be feasible depending upon the nature of the property and its accessibility and feasibility of catering the separate supply. Well, mark this portion to elaborate, because that is the, well, I want to escape route from these submissions only. To elaborate the aforesaid contention, it is submitted by Mr. Sannal that in respect of smaller premises, well, this is also important. Smaller premises, ordinarily one supply line is provided to avoid interjection and overlapping of live wires in order to prevent hazard or accident that may occur. Well, it is very important to avoid any interjection and or overlapping. So to deny me, they have to prove that there is interjection and overlapping. However, he could not rule out the possibility of supply of electricity to a separate electric if it ruled out any hazardous or any accident, particularly when the same property access. Then, my lord, he candidly submits one supply line, such and such, availability in such and such, their co-owner can such and such. Then, my lord, this regulation also kindly to, my lord, take into note, because my other side going to argue that according to Mr. Sannal, Regulation 13(1) of such and such mandates that the supplier shall ensure that all electric supply lines, wires, fittings, and apertures belonging to him or under his control at the consumer premises are in safe condition, and all precautions shall be taken to avoid danger may arise such and such. Then it is further submitted Regulation 7.2 of West Bengal Electricity Regulatory Commission provides that in the event the licensee installs meter at a pole, then the line from meter up to the main switch on the consumer's part should be insulated properly, and there shall be not a joint junction such and such where a switch cut out of such purpose the consumer has to take it. Now, my lord, then the argument, my lord, skip that. My lord, kindly come to P5. My lord, the few lines from the top, the Electricity Act. Here from, my lord, the judgment starts. The Electricity Act 2003, has your lordship got that one? Was promulgated to consolidate the laws relating to generation, transmission, distribution, trading, and use of electricity, and generally for taking measures of conducive to the development of electricity in the promoting competition, protecting such and such. Then, my lord, skip that. Section 43 of the said act creates an obligation of FD distribution licensing, but it is also in Supreme Court. My lord, I am not placing. Then, my lord, next page, what can be gathered from the aforesaid provision contained in section 43 of the said act? It is imperative on the part of the distribution licensee to provide the supply of electricity to the owner or occupier of any premises on an application made in this regard with 1 month from the date. It is also cast duty on the distribution licensee to, to establish the infrastructure for such supply of electricity to such premises in order to meet the demand supply of electricity. The premises has been defined in 251, including land. There is no real artificial distinction assigned in the definition of premises in relation to its nature and the accessibility. It is also answered my first point. The definition of the premises is wide import, which can be visualized. The word includes given in 251. There is no distinction between a single owned building or structure and the building structure owned by more than one person jointly. Even the word occupier appearing 43 does not make any distinction between sole owner, co-owner, joint owner, building structure. It is beyond civil cavil of doubt that the concept of ownership of premises has to be understood in an ordinary sense, and no artificial distinction can be brought between the sole owner and the co-owner of the joint of the joint owner. Under common parlance, the premises owned by one or more other one person are relegated as owner, regarded as owner of the said premises jointly with each other. The co-owner, joint owner cannot be put to lower pedestal than the sole owner, as in every inch of the property he has the right. Therefore, the absence of special compelling circumstances cannot deny the supply. The word owner has not been defined. There is no restrictive meaning can be assigned to artificial distinction can be made. The co-owner, joint owner, such and such, such and such. So the right share recognized. We do not find any fetter in law that the co-owner cannot get electricity supply at a joint premises in absence of a decree of partition or deed of partition having been executed to separate their share, and they have in the law as it stands does not create any embargo on the co-owner to have supply of electricity at joint premises, not distribution licenses have been bestowed in such power to create distinction embargo in exceeding the prayer of co-owner, joint owner. Any such attempt to distinguish one co-owner from another in respect of joint property will destroy the very fabric of the concept.
This was basically on the same property, separate low tension supplies being claimed by separate persons.
Correct.
It was not a case of high tension, low tension being
Correct. But my lord, kindly thereafter, Lordship will find, my lord, kindly come to the next page, section 53, two lines from the top. Is the safety concern? Well, the mandates observation of safety, protection of public, or dangers arising of generation distribution. It is further provided the authority as defined in such and such consultation with the state government. There is no ambiguity in our mind. It is imperative.
Just a moment, Mr. Nag. Mr. Sanyal, Mr. Nag has taken a point that you have filed your affidavit in opposition without first conducting any inspection. Your observations are all general in nature. They do not specifically relate to the premises insofar as you say that the supplies might intermingle or there may be safety hazards. There may be questions regarding safety of the property and persons who are there in the building. All these are general assertions without anything being related specifically to the property whereat supply is sought.
I request your lordships to kindly consider page 153 of the writ petition itself. Reference to your application via the annexure A for providing estimate, etc., for supply of electricity at the above. The finding of our site inspection indicates as a high tension supply exists at the aforesaid premises, and we are not in a position to entertain your request for a separate LT supply.
Yes, but the according to him, the affidavit in opposition does not say that because of this being there in the premises, we say that this premises is risk fraught. His submission on the whole is that it may be that in some cases high tension and low tension supply may not coexist. But whether coexistence of high tension and low tension supply in the subject building is also equally dangerous as it would have been in a different building has not been clearly shown in the affidavit in opposition. It is too general in nature for the ICAC to walk away with a case that there are safety reasons, will not go for.
Let my learned friend conclude. I will deal with myself in the reference to the.
Well, kindly come to the penultimate page. That is important of this.
We'll have to stop after 5 minutes because there is another fixed matter, part third, which I'll have to conclude.
Then, my lord, I can place this judgment and come back on a date, my lord, convenient to your lordship. I will just place the judgment and then I will come back. Because my lord, some urgency is there. That is why I am bothering you. Or otherwise, my lord, fate of employees are concerned. 300, I am told. তুমি যেরকম ভাবে মামলায় হারাচ্ছ আমাকেও জয়েন করতে হবে মনে হচ্ছে
And instead of 2 p.m. can it be
এই
kept to
নামগুলো
the
দে,
first PM?
নাম দিয়ে দিয়েছো।
First half will be problematic because the board will stall as we are seeing today.
Grateful, my lord. Much obliged.
I appear for the respondent bank, my lord. Mr. Banerjee was submitting your lordship.
Regarding item number 25, I have got the statement.
Item number 25 is not called.
And 24 and 25. I put both as good.
Oh, 25 is for the state. Let it be.
In 25, we have got the statement.
Very good.
Not in 24.
24, 25 are being taken together.
Yes, it is.
Why are you not disposing of their application under section 14?
Yes.
Why are you not disposing of the bank's application under section 14?
Regarding that aspect, my lord, in 25, it is, my lord, respondent number 3 and 4, 5. They have filed reply. I have got the state only.
Yes, state is only answerable in 25. Why are you not disposing of the bank's application under section 14? DM is having the representation, he is sitting on that. Why?
Regarding that aspect, I have to go through the records of the case because today morning I have received the book. It's not possible to go through the brief period. Today morning I received the book.
You tell the court next week I'll keep, whenever I keep, please inform the court. Why are you not why have you not taken steps? You will take steps and inform the court what you have done.
Yes.
Why are you keeping the section 14 pending? You have to take decision on that. You cannot keep it pending for years together.
Well, I will take instruction. I will allow some time.
No time on that. The matter is running, you take instructions in the meantime. Yes.
My lord, things is that, my lord, maybe it is possible, my lord, that there is a CGM proceedings also pending.
That we have withdrawn.
That we have
Take a decision and say whatever is there.
Yes,
They
yes,
cannot
that
keep
is very
quiet.
important too.
They cannot keep quiet.
Yes.
They have to decide on
They
whatever.
may have rejected our application.
One way or the other, they have to decide so that matter can be taken
Maybe
up.
they can reject it or they can allow it.
If they allow it, you will take it up. If they reject it, they will take it up. But it has to move. It can't. There cannot be a stalemate situation that you will not take decision for years together. It will remain pending. That can't be done. Take a decision, move forward. Mr. Chakraborty at 2 p.m. Please come at 2 p.m. ওই 2 p.m. একটা no এটা আজকে অ্যাসাইন ম্যাটারে 2 p.m. মেনশন করে গেল হ্যাঁ yes
may I start it or Mr. Banerjee will join it or Mr.
We have almost concluded
So let me Mr. No, my lord, so many judgments are there that to be cited.
Judgments are there
Yes, my lord.
all on fraud.
No, my lord, some judgments are there also.
Show it
No, my lord, Mr. Banerjee will my lord, doing the matter, your lordship.
How do you start?
I am start. Yes, now my lord, please come to that.
Last occasion we supposed to be submitted
list of dates.
I'll give it. I'm preparing it. I will hand it over to you.
You're supposed to give it today. That is what his submission was. And there are few questions for you also. You have not made out a case in the writ petition that there was any defect in the sale notice. That is not your case in the writ petition. That there is any defect in the sale notice or that the bank has suppressed anything. Now you went up to the DRT and got yourself added as a party.
No, not yet. You have made as a party in the civil divisional application.
You did not go to DRT. You have never approached DRT.
They have added as a party in the civil divisional application. Thereafter, came to know about the facts.
But they mandated they are the necessary party. They are the auction party. The DRT will definitely direct them to added as party. They have been added as party.
No. We have never been given any audience before the DRT, and I'm not supposed to go to the DRT.
Add করতে বলা হয়েছে বড়বারদেরকে বলা হয়েছে
May I clear the picture, my lord?
Yes.
Things is that, my lord, there was no scope to the purchaser to add it as a part in the DRT because The sale was challenged before the DRT. And in the meantime, my lord, at the time of hearing of the IA proceedings, entire essay is disposed.
I stand myself corrected, my lord. There is nothing left before that.
Clear. I am the court officer. I cannot hear it wrong submission. So
No. That's
assist the
my
court.
wrong.
My lord, on the basis of that, Honorable High Court was pleased to pass the operation of the stay of the everything, because IA was heard during that hearing of the IA, when the order passed by the learned presiding officer, DRT, essay also disposed of. So they have not got opportunity to added them party. But when I have filed the appeal,
but the SARFAESI proceedings were initiated after the sale notice or before the sale notice?
before the sale notice, much before the sale notice, with so many points of law. Thereafter, my lord, when I have filed the appeal before the appellate court, I have made them party, because otherwise that appeal will be infructuous. Well, they are the necessary party in the appeal. I have made, but they have chooses not to appear in the DRAT. No, I have served them notice. Copy paper book have served to them, but they have choice not to appear in that. That hearing is going on.
I have given the order that they are not taking the amount 14 crores.
I am a purchaser. Milord, I have purchased on the basis of the sale notification. Sale notification, Milord, the bank was supposed to, Milord, follow the rules, giving all declarations truthfully. Now it appears, Milord, after, Milord, the money was paid by me.
Problem, Mr. Bhattacharya, is that the writ petition of yours is silent on what did the bank did not do. You have said that you have taken, you have paid the money, property has been auctioned, sold to you, bank has not given you possession. But there is no averment saying that the sale notice suppressed anything. The sale notice is supposed to say something.
I am not supposed to know. I am not supposed to know whether suppression or not.
That is supposed to be the ground, Mr. Bhattacharya, for you to assail the sale notice. Because if you are not...
I am not against, Milord, the sale notice. I am saying that you have misled me. Because
that exactly is that
the misleading was that when the statutory authority, Milord, publishes a notification in terms of the rules, they ought to have been followed the all procedure. Now it appears, Milord, they did not disclose that there are litigation pending. How do I know that there is litigation or not? Kindly come to, Milord, my paragraph 5. I have simply said that
এনাদের রিট পিটিশনটা কোথায়? অশোক কুমার ঘোষের রিট পিটিশনটা ন্যাশনাল ব্যাংকের নয়, ঘোষ এটা ইয়েস প্যারাগ্রাফ
therefore I have no, Milord, I am not a borrower that I am challenging the notice.
Mr. Bhattacharya, this writ petition, when this writ petition was filed, you already knew that there were SARFAESI proceedings. At the time of institution of the writ petition, you were aware. Then also you have heard that this was not made known to you, or you did not know it.
Well, I say that kindly come to the notice. The notice itself would show.
No, but notice would show that it was not mentioned.
Then that is good enough.
Well, grounds one is there.
Milord, that is good enough. Milord, if the notice itself statutory, Milord, statutory compliance is not made, Milord, I don't have to speak anything. Notice speaks for itself.
That may not be sufficient. You have to say that you have been misled.
I have said that I have purchased on the basis of the notice. The notice, if supplies something, I am not supposed to know. That is consistent view of the courts. A purchaser, kindly, may I just make my pleadings? Your Lordship will get it, Milord. Some pleadings are also, Milord, called implied pleading. If your Lordship requests, I shall cite authorities. Kindly come to, Milord. Paragraph 5.
Paragraph 5.
Yes, respondent bank published a sale notice by virtue of the power conferred against 13 so and the rules. Sold the above mentioned as a secured credit in favor of the petitioner. I have made the payment. Then, Milord, sales certificate was issued. And sales certificate also suppressed fact. That's why they could not hand over possession.
But all this is your submission, Mr. Bhattacharya. Where is the averment in the writ petition?
Yes, my lord, the duty of the court is to, my lord, reveal the truth.
There are certain.
I have advanced basic point that I have been misled by the notice.
So where is that point that you have been misled by the notice? Show me that one line.
But again, I say, kindly excuse me, my lord. I am not supposed. I say, see the notice. A statutory notice by
Mr. Bhattacharya, that could have been sufficient if before it being put to your knowledge that there was a surfacey proceeding. Then if you say there are implied pleadings, this also may be implied that you were in the know of the surfacey proceedings and you.
I don't have to plead.
You have to plead.
I am a purchaser. I have paid my money. The property is not being handed over to me. How the sale is complete?
If you say that the sale has to be upset because of you being misled, you have to say that you have been misled. You cannot just say that I should imply that you have been misled.
My lord, will I kindly excuse my saying so? That the duty of court, I repeat, with authority, is to, on the basis of the materials, to reveal the truth. Lordship is looking at the role of the statutory authority. Bank is not a private agent. The statutory authority, is trust.
There is a difference. There is a difference in the stage. You please correct me. You know better. There is a difference in the stage. If you had approached the court at a stage when you really did not know about the surfacey proceedings and you would have made these submissions, this submission would have held good. Today, when you approach the court knowing fully well that there are surfacey proceedings and even then you don't plead that these surfacey proceedings were not informed to me, does it not imply that you were in the know of it and therefore you have not pleaded it? There is a contra implication.
I was not in the know when I put in my money.
You may not. Then that also has to be. That also has to be said, Mr. Bhattacharya. Today you are saying this, but whatever you are saying, everything the court has to presume.
No, court has to go through the document.
No, court has to go to through the document along with the pleadings. There has to be a support to the document from the pleading. The document by itself.
May I just, if I make a pleading contrary to record, what would the court rely upon? My pleading or the record?
The document
here my lord.
No, the court will look at the document in the light of the pleadings and look at the pleadings in the light of the documents. Now, if I look at the pleadings in the light of the documents and look at the documents in the light of the pleadings, there is one possible implication that you were in the know of it, which is why you have not pleaded in the writ petition.
But what it will ultimately lead to? Then I can amend the petition and come. Would that lead to? Therefore,
that doesn't, after the court putting in the question, if you amend
when the court puts in question, court must have looked into the document. From the document I find that
Mr.
these things are there.
Will look into the document as well as the pleadings, because your case is that you want the case the sale to be upset, but you will not plead that you have been there has been any misrepresentation. You will not plead that there is a fraud played. You will not plead that the notice is bad because certain encumbrances were there which were not made known to you. You will not plead all of this. The court will have to presume all of this because you feel that the notice has to be read in this way and the notice has not been read in this way. Therefore, the pleading should be by implication contain all of this. This is too much of a presumption, Mr. Bhattacharya.
Lord, my cause of action probably I could not communicate to your lordship. I am not at all bothered about whether the notification is suppression of fact or not. I only get pinched when my money is being withheld without handing over the possession. At that stage, I come to court, and now it's the duty of the court.
Notice is the basis for you to hand up the money. You entered into the contract on the basis of the money. You say that the notice did not say about certain things and therefore I was misled. But all this you are saying from the bar. All this is not there in the petition. You want me to assume this by seeing the notice?
No, I am sorry to say, Lord, I am not inviting your lordship to assume anything. Kindly appreciate what is my case. My case is that I have put in money. You have given me a sale certificate. You are not giving me possession of the property. At that stage, when they come forward in defense that I could not hand over the possession of the property because XY reason, that becomes a part of the defendant's pleading and before your lordship. Then lordship will definitely go into the issue whether, my lord, their pleadings are genuine and justifiable. I am on that. The onus is not on me at this stage.
Very well.
And that's why, below the Supreme Court and other judgments which your Lordship has been pleased to, it was cited before Lordship. In case of purchasers, the always court says the purchasers have little role. They should not be deprived of the benefit. Now, would I have to wait, Milord, for the proceedings between the borrower and the Milord bank and wait for eternity?
That is where it becomes important, Mr. Bhattacharya. Whether you will have to wait for it or not will all depend whether you entered into the contract knowing that the proceedings are there or not.
No, when I entered into contract,
pleading becomes important. This is why all the endeavor and shouting of the court was only to make this point clear, that this becomes important only because you want the sale to be annulled on the point that you have not been able to get possession of the property because of a pending litigation. Now, today your case is not in the writ petition. It is not your case in the writ petition that you are not in the know of the pending litigation. The court has to imply by reading the notice and the absence of your pleadings in the writ petition that you are not in the know of the know of the pending proceeding. Therefore, you should not be allowed to wait till the pending proceedings, and the money should be made over to you and not the property. Now, this assumption will the court make on the basis of the pleadings and the notice or not is the question which I have to answer.
Milord, I again reiterate, Milord, when the materials are before the court will, Milord, come to truth on the basis of the materials before the court, irrespective of Milord pleading.
Very
Milord, to that, if your Lordship wants, Milord, I shall file a compilation of judgment and hand it to your Lordship.
Please do it. Please do it.
Yes, because when the materials are before the court, it is the duty of the court to come to a reasonable, truthful finding, irrespective of pleading. I am not alleging anything malafide. I am not alleging anything that I was numb. I did not know. I say I have purchased on the basis of the notice. You could not hand over the property. Now they come and say X, Y, Z. Why those X, Y, Z will be considered by the court or not is up to your Lordship.
Yes. Yes. Yes.
Thank you.
Thank you. Yeah. Yes, Mr. Banerjee, complete.
Lord, since we had an interesting question, my lord has raised today.
No, that was for him, not for you to answer. You answer your question and finish your side.
My lord, I have a duty to serve your lordship. My lord, may I serve? My lord, how, my lord, the pleadings made in a writ petition is to be read. My lord, what's the difference between, my lord, the pleadings in a plain and written statement and pleadings in a written statement? And what is, my lord, the duty of a writ court? My lord, how a pleading made in a writ petition is to be, my lord, read? My lord, Honorable Supreme Court has, my lord, given certain guidelines in 2026.
It started from 1988, Bharat Singh's case.
Referred
2026
to
is
you.
one
Referred
matter.
to you. Referred to you.
I'm relied upon to.
May I, my lord, hand up? It's 2020.
2181 অনেক দিন ধরে
2026, my lord, SCC Online, Supreme Court 1319.
লাগবে না প্লিডিং
19.
Yes.
Kindly see, my lord, the author's name.
Yes.
Kindly turn to, my lord, paragraph 35. Kindly see, my lord, the question posed to the Honorable Court. The exact question which my lord is posing, my lord, to us, which is, my lord, which has fallen from your lordship. The exact question. কি হলো? আরে বসো না, বসো।
এটা নিয়ে ওটা দিয়ে দে তুই একদিকে লেখা পছন্দ করিস না
Now, should I, my lord, read it out aloud or no? Absence of requisite pleadings and specific prayers. Here, my lord, there is a prayer. Here, my lord, there is a pleading also. I'll show to your lordship, my lord, from Mr. Bhattacharya's writ petition. There is a pleading also. My lord, let us assume, for the sake of argument, that there is no pleading. The Supreme Court in multiple rulings has cautioned that in exercising writ jurisdiction under Article 226, the High Courts must confine themselves to the pleadings and the prayer clauses. And granting relief beyond what is prayed for is not permissible in law. My lord, that's what, my lord, Amratlal Kathali, my lord, was the law.
Page 40, come to page paragraph 43. That is what you want to drive the court at. I am alive to that.
Yes, my lord.
It's not that simple.
Sure, my lord, my lord is alive to that.
I'm alive to that, but my questions are still not irrelevant. You want me to hold that there is a malafide. There has to be a pleading. It is not that simple.
Kindly
Once you
take.
want me to hold that there is a malafide, once you want me to hold that there is a
Well,
misrepresentation.
malafide is a higher test. Let us.
It is that only. Higher, lower is all
Milord,
jugglery
may I
of
put
words.
it in this way? I am nobody, Milord, to argue, Milord, Mr. Bhattacharya's writ petition. Milord, just an officer of the court, Milord, may I assist? Milord, if, Milord, the case is not put, Milord, on that higher pedestal, if my lord's, Milord, conscience is shocked by reason of non-adherence to the mandates of the statute, which is, Milord, apparent on the face of the record, Milord, would my lord, Milord, ignore that? Milord, I was just posing that question to myself. Milord, if there is, Milord, a notice where, Milord, they were under a statutory mandatory obligation to, Milord, disclose the encumbrances known to them, and it is, Milord, emerging from the, Milord, materials brought on record before your lordship that those encumbrances were known to them in the form of, Milord, litigation, in the form of tenancy, which, Milord, I have shown to your lordship on the last occasion. In opposition, Milord, I have taken that pleading, and my lord is hearing these two matters possibly, Milord, analogously. So, Milord, I am, Milord, bringing forth that, Milord, there are, Milord, non-adherence to the mandates of the statute. Milord, if that be so, whether, Milord, the Honorable Court exercising great jurisdiction, equitable jurisdiction, can, Milord, overlook that? Milord, that is what, Milord, I am posing. This is the question I am posing to myself and trying to answer to your lordship. Now, Milord, 43 says, one of the exceptions is when the court is convinced that the petitioner is legally entitled to more than what has been claimed, but might have claimed less due to ignorance of bona fide mistake or inelegant drafting of the writ petition by his lawyer. Milord, I am too small a fry, Milord, to say this, but, Milord, this is what the law, Milord, that has been laid down by the Honorable Supreme Court. Since substantive justice cannot be allowed to be trumped by technicalities, if the record before the High Court clearly evinces entitlement of the suitor to a wider relief, what is claimed, the opponent is put on notice. Here, Milord, nobody is asking for something which has not been prayed for in writing in black and white. Milord, something is being prayed for, Milord, which is there in writing in black and white. May not be, Milord, a case is happily not made out to the satisfaction of your lordship. Milord, the case before the Honorable Supreme Court was a worse case.
Let me be more clear.
Yes, Milord, yes.
All of you have shown me the law.
I'm
Understand
so
the
sorry,
fact
Milord, it's
also.
not.
Look at it in the facts of this case.
Yes, Milord.
The purchaser did not know about the DRT proceedings at the time when he entered into the sale. Let us assume it.
And tenancy.
Very well, let us assume it. Now he enters into it. There is a writ petition, plethora of proceedings thereafter. Even thereafter, this assertion does not find place in the writ petition.
By of a supplementary affidavit or otherwise?
Nothing. As of now. And you are saying that the sale is illegal. Would it not be implied then that the borrower was knowing, the auction purchaser was knowing this? Would this not also be implied?
I'm sorry, Milord, I could
Because
not follow your lordship. I'm so
auction
sorry.
purchaser enters into this auction sale contract or transaction without knowing that there is an encumbrance. That is what appears on the surface. Then there are proceedings to which he is a party. He comes to know that there are proceedings going on before the
take the point.
He doesn't take the point. And he challenges the sale in a sense that he wants his money back because the property, his only grievance still remains that the bank has not given me the property despite me putting in the sale price. Would it still not be implied that he knew about it? Would the court go that far merely because the sale notice shows certain defects? He doesn't take this point even after knowing this. Is it a case of inelegant drafting or is it a case of implied knowledge?
May Milord answer? Try to answer, Milord, and convince your lordship's, Milord, conscience.
Now that interjecting here, Mr. Milord, I have mentioned about cases. Kindly, Milord, note down. I don't know whether my junior can supply these cases. 2012, Volume 5, SCC, page 370.
Yes.
Paragraph 38, 51, 52. What should be the role of the court in such a situation? And the next one is 2022.
Yes.
Volume 20, Supreme Court cases, page 233.
Yes.
Paragraph 17 and 19. What is the purpose and effect of Evidence Act and pleading? Madam, kindly excuse me, Milord, I am not able to cite those since I am
Not a problem.
virtually.
I'll look into it, Mr.
And I will,
Bhattacharya.
Milord, subsequently, if your lordship
because-
so desires, I can explain, go and explain also.
No, not a problem at all. I shall see, because this dialogue is necessary.
Yes.
I would like to have everything clear.
That's true. That's
that
true. No, my lord is very open. That's good.
May I, my lord, try and answer? My lord, what is passing through my lord's mind, my lord, if I have correctly understood, is despite knowing all these encumbrances, when he is
And when it is your case that the price is shockingly low.
not my case, my lord, not my case.
No, it wasn't
My
your
lord,
case. Before the DRAT is not.
yes, before DRA.
Yes.
Yes.
That is what you said.
Yes.
You said that in
Correct,
551. I
correct.
remember.
There,
that.
my lord, we are not on the same footing.
So where
It has been
where
turned
you
down.
case it that the price is shockingly low, where the pleader does not plead that he knows about it.
Milord, I have.
Court will imply
Milord,
that
I anticipated, Milord, this query. Milord, I have an answer to that. May I answer, Milord, to the first question first? Milord, whether this would constitute, Milord, a waiver. Milord, possibly that is, Milord, the question that has fallen from your lordship, despite knowing the encumbrances, if one does not argue this. Milord, the date of knowledge, my lord is ascribing to a point of time, which is post-initiation of, Milord, my learned senior friend, Mr. Bhattacharya's writ proceeding. Post-initiation. That's, Milord, the time when, Milord, my lord is ascribing the time, Milord, of knowledge of the writ petitioner. So, Milord, there was no occasion for the writ petitioner to draft it in the writ petition. Now, when in course of this proceedings, the writ petitioner could come to learn about this, he did not, Milord, file a supplementary affidavit.
but this writ petition was filed after the civil revisional application.
Yes.
Why was it not that time for the writ petitioner to incorporate it in the writ petition? It
There
was
is a leave granted in
at that point of time. He knew that SARFAESI proceedings are on.
Tenants, Milord, I am on tenancy. Tenancy, I am not.
on SARFAESI
Oh,
proceedings.
yes,
Tenancy
that he
will
knew.
come later.
That he knew.
Tenancy will come later.
That he knew. That he knew. That he knew.
They're contesting there.
Yes, sir, that he knew. রাগ করছেন।
No, রাগ করবো।
That encumbrance. Now, tenants property can be purchased with tenants. There is no embargo on a person.
No embargo, but Milord, the price, Milord, stoops down.
Price is something else that you will take up before the DRT. Whether for the writ court to intervene, that is sufficient that the property is tenanted. That is not his case in the writ petition also.
Milord,
It doesn't say that I have not been given possession of a clean property, or I have not been given, or I am being sought to be given possession of a tenanted property. That is not the case. When we look at the case as a writ court, we look at it and in all settings of the fact. I am not. It's not that I'm not cognizant of these judgments or this position in law. I know that.
Milord,
But
kindly do
still,
not embarrass us, Milord. My lord,
there is
yes.
something more that we have to see. We have to go a step further here. I am not arguing a person's case.
Not
I'm
at all,
looking
Milord.
at
My lord is opening my lord's mind so that, Milord, we can answer what is passing through my lord's
No, I
mind.
have to see the way
Both the sides of the coin, my lord has to see. My lord is seeing that. Now, let us assume that, Milord, despite knowing everything, he did not, Milord, utter a single word. Milord, what would be the consequences? Milord, may I answer that? Milord, then, Milord, there are two ways of looking at it. One is, Milord, voluntarily giving up his right to, Milord, say all these things before your lordship's court, which, Milord, in single word is waiver. Milord, to constitute waiver, Milord, three elements are necessary. The third element being, Milord, conscious giving up of right. Mere silence, Milord, does not constitute waiver. Milord, subject to, of course, correction by your lordship. Here, what my lord is getting is, Milord, an absolute, if I may say this, Milord, even conspicuous silence. Milord, may I, Milord, again put this question to myself, whether, Milord, a conspicuous silence would, Milord, impliedly constitute waiver of, Milord, the statutory rights, or, Milord, would act as estoppel of law. Milord, let us assume that.
Of estoppel. not a question of estoppel at all.
Rule 9,
It's
if
a
not,
question-
is followed.
It may be a question of waiver. It's not a question of estoppel.
Very well. My lord, I don't run that higher case. However, mere silence, my lord, is not waiver. That's what, my lord, possibly in this decision has also been, my lord, discussed. My lord, may I just check one? Yes, my lord, it's there. My lord, paragraph 45 onwards, 46 especially. It's there. My lord, oh, those three, my lord, points have also been, my lord, indicated. Kindly, my lord, have a look at Roman 3. Despite the knowledge of an existing right, that person has voluntarily, consciously given up that right. Mere, my lord, it's exactly worded, mere silence or inaction or delay to enforce the existing right does not constitute waiver, since there must be a clear conduct revealing, revealing
Yes.
that right has been given up.
Yes. Now, whether this is not a clear conduct.
My lord, that is, my lord, for my lord to decide. My lord, I say, and my lord, definitely Mr. Basu would say that, my lord,
Filing a writ petition.
oh, my lord, that is a clear conduct. My lord, I would say it is not. I'm sure Mr. Bhattacharya would also say it is not. That is, my lord, for your lordship to decide. Now, my lord, coming back to the writ petition filed by which, my lord, I was arguing. To the writ petition filed by Mr. Basu. My lord, if my lord is set up, my lord, a touchstone to test the pleadings, my lord, I'm sure my lord will be applying the same touchstone for test both the pleadings.
Of course.
So, my lord, his pleadings, which is full of, my lord, not only suppression of facts, but also, my lord, false statements made on oath. My lord, that pleadings, my lord, cannot succeed. My lord, that writ petition cannot succeed. My lord, there are decisions, I may trouble your lordship with one or two, which says, my lord, when it comes to writ jurisdiction, my lord, one may have a wonderful case, but unfortunately says something wrong in the writ petition or suppresses something which is otherwise material. Despite having a wonderful case, my lord, he must be shown the door. That's what, my lord, repetitively, my lord, the Honorable Supreme Court has said. Don't, my lord, in so many words, don't pollute the stream of justice, court of, my lord, equity and good conscience, etc., etc. So, my lord, so far as Mr. Basu's writ petition is concerned, my lord, I have shown your lordship 5-6 points, which, my lord, there are statements which are belied, my lord, I don't say even contradicted, belied by the documents placed on record by him only. My lord, there are statements which are, my lord, negated by some other affirmants in the body of the same writ petition. My lord, there are suppressions galore. And
that you have shown last time you showed.
yes, and my lord, we have made, my lord, a rough, my lord, chart. Just, my lord, for my lord's, my lord, easy comprehension, convenient comprehension. What are, my lord, the broadly, what are the false statements and suppressions? Thirdly, my lord, today Mr. Basu is asking for a direction upon an authority to, my lord, expeditiously hear out a section 14 application which has been abandoned. And that was suppressed. My lord, that application was followed by a subsequent application before a different authority on, my lord, on the same loan transaction regarding the same property. My lord, two parallel proceedings cannot be simultaneously done. My lord, that's the law. My lord, I am not troubling your lordship with decisions. We are carrying those decisions. So, my lord, two parallel proceedings could not have run even for a day. The moment the second application was filed, parallel running, since that was not permissible in law, impliedly or by necessary implication, the first application stood abandoned forever. Now, what possibly Mr. Basu has done, Mr. Basu's client has done, has withdrawn or has sought to withdraw the second application. But that is nowhere to be found on the records before your lordship.
It was the leave of the court. It was filed. It was in the order sheet subject to correction. It is mentioned there. It has been withdrawn because in wrong forum. It has been.
I have not come across that document. I have not.
Because it was filed in the wrong forum.
But I have not come across that
I will
document.
check up, my lord, need not be trouble. Check up and give this date of the order.
Now, my lord, unfortunately, let me, my lord, assume that, my lord, that has been withdrawn. Though, my lord, that is, my lord, I am yet to find it out, my lord, from the records of the writ proceeding. Let me assume, my lord, that it is there. That also does not help my learned senior friend. I tell your lordship, my lord, why?
Yes.
My lord, may I tell your lordship why? Even if that is assumed, which, my lord, assumption cannot be done, but let us assume for the time being. My lord, the moment the second application is put in, since the law is clear that parallel proceedings cannot run even for a while, my lord, the first application automatically stands, my lord, given up and abandoned. So, my lord, he cannot inject life to a dead cell now. Now, my lord, when all these facts are before your lordship, my lord, I was just wondering aloud whether my lord would allow them, my lord, to inject life to an application which has been abandoned and to proceed with that application by passing, my lord, a decree, by issuing a, my lord, a writ of mandamus.
Yes.
My lord, should I, my lord, rely on one or two decisions on parallel proceedings?
You are free, whatever you want.
Everything.
যখনই my lord বলেন না ইয়েস তারই মানে হচ্ছে আমার এগেইনস্টে আছে
15 হয়ে গেছে কিন্তু সেটা খেয়াল রেখো একটা 15
Lord, may I waste my lord's time any other day 15 or 10 more minutes.
Finish it that day then, so that
if he's want to rely any judgment, if it's handed over to me earlier, I can on the spot I will.
I'll do that any day,
we
my lord,
can
10 minutes.
speed off.
10 minutes, my lord, by the clock. My lord, I have a feeling, my lord, I have not been able, my lord, yes, to pierce through my lord's mind. My lord, I'll try.
Don't go by the questions. My questions will be equally harsh on Mr. Basu when he takes up the.
My lord, I'm waiting for that.
That
should be harsher.
That Bengali
faced it when
that
he
Bengali
began
proverb. That Bengali proverb. Don't rely on the mind of the judge.
This is good for the council to learn and go for research work.
No, the more I display my ignorance, which actually I have, the more I also get enriched.
My lord, it's a blessing.
We are not concerned whether man or enriched or not, but we are.
I am concerned, and
I am not concerned.
That will
Say,
be good
we are
for
not
the
concerned.
My learned senior friend's enrichment, my lord, is in
What
other
we are saying
terms.
that
yes, of course.
Okay, my lord, ask some question, my lord, to endure to benefit of the councils to answer and to update it.
But I am not interested in that.
No, certainly not. Certainly not. Certainly not.
Any day, which is
I'm also interested in my enrichment, as you are not in mine.
It will automatically comes. If your lordship ask something, decide something, automatically man will enrich.
It is good to have this dialogue. Even
Yes.
if at times
So
we have
speaking judge is best, always
because it rewires.
Speaking judge is always welcome.
Passes a speaking order.
নাহলে বুঝতে পারি না আমার মাথায় কি আজ হয়ে গেল এটা
Any day which is convenient to your lordship. But accepting 18th.
সেদিনই হোক তাহলে
Yes. Acharya, when can we have it?
Will it any day?
হঠাৎ মনে হচ্ছে দিতে যাবে না হঠাৎ মনে হচ্ছে দিতে
স্যার এটা শেষ
Mr. Bhattacharya, your video froze.
কাল
Oh, now it's yes.
Yes.
Network fail.
When can we have it, Mr. Bhattacharya?
আজকে রোজের নালে খেতে পাবে না কি করবে
Will it next Friday?
Next Friday. Next Friday. Next Friday we can have it.
Yes. I'll be there.
Maybe in the
Same time.
First half. Yes.
Same time.
Same.
You will take 10 minutes.
Maybe 11 or 9 minutes, not less
15,
than, not more than that.
15.
Yes.
And Mr.
Yeah.
Basna?
15.
By the clock. By the clock.
I'll reply.
15.
I'll only consider their judgment.
We'll have it on that day, and if necessary, we'll spill it on to one more day and we'll finish
So
it.
grateful.
I think it will be
One
done.
more day, in any case, I will take for myself to keep it again because I may have queries. Once
It
I
would
close-
be a worst day for me, Milord, I can
No.
guess.
The lawyers never defeat, never win.
Yes. Heard Mr. Banerjee, learned
Whatever.
advocate appearing for the borrower. Say দুটোতেই একই জিনিস থাকবে. Full stop. He has not yet concluded. full stop. As requested, list this matter once again on August 7, 2026 at 12:30 p.m.
So far as my lord, the writ petition which my landed friend is arguing, we have not, my lord, for petitioner we have not made any submission.
Very well.
We are only made an application. Can you
Because
consider
your
this?
submission was
In the reply, I will. In the reply, my lord, I will add that. And my lord, Mr.
No,
my
but
landed
you will have to. You will have to cross that hurdle of wholly deficient and suppressive pleadings that he has argued.
He has argued.
Yes.
My first argument will be, I am telling your lordship.
Who is he?
Can he make any submission in section 14?
He has been added as a party.
Maybe added.
Order of
My lord,
court. No,
my lord
he has
knows.
been added as a party. I will hear him.
No.
I have.
My lord will be hearing.
My lord will not waste energy
Hello.
today. Let
No,
us
I'll
wait
give
for
the
the
point.
next Friday.
Necessary party and proper party.
No. That point you please
I will.
forget. You ignore
Let
that
the state,
point.
my lord.
Argue on merits. How
I
can
will.
that
Let the state, my lord. Let the
state has
state.
said yes. Who?
Suppose
That we
Please
recorded
take
in the order.
instructions.
Can you pass an order then?
No, he's there. He's
No,
there.
no. Order for
Him to bring it.
The learned advocate appearing
That's
for
not
the
free.
state respondents shall take appropriate instructions and make appropriate submissions on the next day.
The other side is they have not.
I will not take it ex parte. Don't worry.
আর কেন অন্য ফিক্সড আছে অন্য মামলা
Before Lordship takes up the matter, my lord, item 40, I have some urgency, my lord. I have to leave, my lord. The other side is here, my lord. Can you also please to take up the matter, my lord? 40, my lord.
My lord, one mentioning
Those are pending. That has not been taken.
Where you oppose.
My lord, we have no objection with regard to their renovation. But my lord, we only object to the fact that with the plea of renovation, they are making a completely new structure.
No.
This is the my lord,
My learned friend has not followed. I have two sets of applications. 151, first 151, that is not my pending structure was there. I filed a 151 for modification of the status quo so that I can modify the structure. That one. And second 151 with regard to the repairing of my dilapidated condition.
So dilapidated, let him repair. So far as modification is concerned, that will be taken up by the learned
Both
trial
the applications will
I will direct the learned trial court to dispose of. When is the date?
14/12. That is the difficulty.
He will pray for preponement.
My lord.
You please be there on notice so that the learned court
Prepones that
it.
we
May
Then let him.
May I humbly, my lord, my other side is here, my lord, kindly fix a date so that
No, that will be problematic, Mr. Samanto, because I don't know the learned court's diary.
court is vacant. That is also difficult.
I'll give you opportunity. I mean, provide for it. You appear before the court having charge, the learned judge having charge of that. He will hear this application at least. That
And
will
my lord,
be
one more difficulty was them, my lord. When I appear in the suit, my lord, a 151 filed by them, that copy not served, order passed against me.
that you challenge. That will be challenged again.
That is also a challenge before your lordship.
In the last order, my lord, it is specifically directed, my lord, it's specifically recorded that whether, my lord, if takes up the first page where the order is there, just before the annexure, 20th July, 20th May, my lord, the last portion. My lord, in view of the defendant number 1 and 2, should appraise the court whether they are willing to contest the suit or not.
No. His contention is that the 151 application granting police help has been allowed without giving them an opportunity to
My
represent.
lord, they have not filed their WS and WO. They have been served.
That is not the business. Whether I filed or not, my lord, 151 filed by them after my appearance, that is to be served upon me.
It is a partition suit.
Yes.
That should be the application for police help ought to have been allowed after hearing them.
Yes, my lord.
I will set aside that order, remand it back for hearing, and after hearing the court will pass order. So far as the other two applications are concerned, I'll request.
Kindly give me a time limit, my lord. My lord.
This revisional order gives you time
To
to
the
file
to the
WS.
to the 151, we cannot file WS and WO.
No, you had prayed for time to file WS, and he's granting you time to file WO. You have to read the entirety of the order. Don't
As your
come
lordship,
after
as your
the
lordship,
sentence
as
and,
your lordship.
punch the order. No,
No,
that's
as your
not
lordship.
right. Yes.
Lord, the parties to act on the server copy, Lord. Otherwise, I have to come.
Yes, server copy always.
Yes, grateful to us.
As good as a certified copy.
As your lordship.
না এনাটাকে কল করে দিন
23.
Mr. Chakraborty, what is so urgent? Why can't you wait for 2-3 days? We can have it then.
Only thing I need protection, my lord. 4th is the date, next date has been fixed. And competent authority has said candidly that you bring stay order, otherwise I will proceed with this.
4th is the date.
4th is the date. There is the coming Tuesday. That is my only urgency.
And stay order for what? What will he
Not
do?
to take any action on the basis of the, he may proceed, but not to give any effect to that order. I need just protection.
The last
I
objection I
need
have
just
submitted,
that
my lord,
protection.
it's an admitted position. My lord, the petitioner was to
Acha, Mr.
pay
Pan,
back.
My lord.
You are in possession of the land, that excess land.
No. I am not. That is there with them because that is required to be. That's why I submitted before your lordship that the joint inspection which was held subsequently, that is to be taken into consideration first because in the judgment it has.
You are not in possession of the excess land.
No. I am not.
Excess land is in possession of the metro authority.
Yes.
Yes, my lord, that is excess land.
Then in that case, what for are you seeking money? If you are in possession of the excess
It is
land,
the
you are
excess amount, my lord. Excess amount.
You are in possession of the excess
No,
land.
excess land. It was never acquired, my lord.
No, it was acquired. You
Yes.
can't say it
So,
was
my lord,
never
kindly,
acquired.
my lord, kindly see, it is the portion
Mr.
of the land.
Chakraborty,
Yes, my lord.
the land was acquired in terms of the notification.
Yes.
There was an award which records that portion of land
Yes.
having been acquired. Despite acquiring a specified demarcated portion of land, you utilized a different
Yes.
portion. Your utilization is defective,
Yes.
not the acquisition. Acquisition is proper. You had acquired the proper land. You had paid compensation to him for that acquired
Yes,
land only.
for the land which is in excess of what has been actually acquired.
No, Mr.
Yes, my lord, kindly
Mr.
see their petition
Chakraborty,
as well. It will be clear.
I have seen it. The case is that say 10 acres of land were to be acquired. 10 acres have been acquired. But what has been utilized is 5 acres from his land, 5 acres
Yes.
from someone else's land. That is the case.
That was never the intention of the notification.
It may not have been
There
the
are two
intention.
dabs, my lord. Yes, my lord. Sorry. I am sorry.
Either you speak or I
My lord,
speak.
please.
It may not have been the intention of the notification.
Yes, my lord.
In terms of the notification, you are to acquire 10 acres of land from Dagex.
Yes.
You have on paper acquired 10 acres of land from Dagex. You have paid the owner of Dagex the compensation, full compensation for the entirety of 10 acres. But when the time of utilization of the land came, you utilized 5 acres from Dagex, the balance 5 acres from Dagwai. Nobody has come forward as of now to claim compensation in respect of Dagwai.
Yes.
Now, in respect of Dagex, if you are in possession of the entirety of the 10 acres, you may not have utilized. So, as at present, the situation is that you have in your possession 10 acres of Dagex, 5 acres of Dagwai, and you want him to pay money for that 5 acres of Dagex which you have not utilized and which is not in his possession also. If it was in his possession, I would have asked him to vacate immediately. Yes. But now, so far as your mistake is concerned, both of you have jointly committed a mistake at the time of utilization. Now, he will not have any right to the land. That I will clarify. He will not have any right to the land. You have your land. You can utilize in whatever manner you want.
Station constructed, utilized fully.
Even then, no, your land has not been utilized.
No, my land has also been utilized for the purpose of construction of the metro railway. The other excess land that has also been utilized as per notification.
Kindly
hear out any other day, kindly protect me.
The question which has fallen from your lordship was that the urgency. The urgency is,
you are in
there cannot be any urgency to that. My lord, may I humbly pray for one thing, my lord? May I just answer to the exact queries, my lord?
No, you will not be able to.
I can come back on Monday or any day, my lord.
No, you come back on whenever you want. Don't proceed further in the meantime.
Well, kindly that protection. Every day I am in under.
They have been paid an amount for which they are not entitled to.
Of course they are. because you have utilized, you are in possession of that land.
To
You
which
you are in possession of the entirety of the plot that you had acquired. Don't say that. You are in possession of excess land from
Yes.
someone else's dag also.
to which they have to which the petitioner has no entitlement. That is a
Let him
therefore
not be.
therefore,
He's
therefore
not
there
claiming.
cannot be any
Mr.
urgency to
Chakraborty-
that.
Mr. Chakraborty, there is no unjust enrichment. Unjust enrichment, if there be, it is with you, because you have been in possession of his land and someone else's land to whom you have not paid. Now that person has not come. Good luck for all of us. If this person has come, he would have come so far as his prayer for revision of compensation. He is not
Subject to
entitled.
correction, my lord. This petition can only be confined to the rights of the petitioner only, my lord.
Yes,
My lord,
it is.
kindly, my lord,
It is the
appreciate
right
that
of the
so far the
petitioner only.
artist.
That is why I will reject the order which has been passed by the
My lord,
appellate
kindly allow me
party.
to submit. It is a specific query on the last occasion. My lord. It'll take some time, my lord.
Unnecessarily you will hold the other members of the bar also,
lord, I do not
and
want,
you
my
will
lord.
walk away with the same
No,
order
my
which
lord,
I am
I
now
do
saying. I'm not going to change my mind
My lord,
because
I
I'm
do not want to
satisfied.
trouble your lordship, but kindly allow me to some time be given, my lord. I do not want to trouble the bar as well. Some time be given.
Then
Today,
you don't
tomorrow,
take
any
steps.
day, my lord.
Then you don't take steps in the meantime,
yes,
because every time you unnecessarily
It should be
press
on
that you
Monday,
have
my lord.
urgency.
If the business of the honorable court does not permit today, my lord, I'll come back on Monday. Even on tomorrow, my lord.
Steps. You show me what prima facie case you have. What case you have?
But this is
To hold up excess land and ask him to make payment. What right you have?
my lord, the entire proceeding culminates from a review petition
Whatever it is,
filed by them.
whatever
My
it
lord,
is.
kindly
If the entire proceeding is bad because of the initiation of the proceeding by way of a review, then on that proceeding only, how could you pass an order seeking him? He cannot be worse off in his proceeding. The manner in which you say that he cannot have better rights than what he has claimed in the application here. On the same analogy, you also could not have got better rights on his application.
Well,
How could he be
kindly see his petition in that case. my lord.
whatever it is?
Kindly see,
his,
my lord, what
his
is the
petition
pleading,
is
my lord?
liable to be dismissed. Very
case
well.
which
Mr. Chakraborty, his petition is liable to be dismissed. You ought to have dismissed it. The extra mile that you walked, saying that his petition will be dismissed.
Yes.
Now he is liable to pay back this amount. Where does this jurisdiction come from?
Well, that I'll try to satisfy your lordship.
How will you
allows-
try to
my lord.
tell your
This is-
151
I
argument?
would say, my
Your
lord,
151 argument that you made last time does not cast ice.
my lord, that is where I want to join the cause, my lord. It is the case of the petitioner as well.
It will be
I
total
can
wastage
show
of
that,
time.
my lord. It is the case of the.
Will not improve the law. If it is his case, he is also wrong.
Yes.
It is not that if he says that 151 will apply, therefore I will believe it. That is not the law. It has to be said by the law.
However, this is something for the ends of justice.
Yes, ends of justice only
And
says
my
that
lord-
you cannot have best of both
my
the
lord-
worlds. You cannot have the land as well as the money. You have
Well,
to,
the provision of that particular statute ended 16B.
you can go on
which,
till
my lord,
430,
only confined to.
but the result is going to be the same. You are unjustly holding 10 acres or whatever the land area is. It is not that I would have understood if you were in occupation really. That is why my first question to the learned advocate for the petitioner was as to whether he is in possession of the excess land or not, which he says he is not, and you are. If you are in possession of the excess land, what right you have to call upon him to make payment in respect of that land? How, under what law?
Because I have paid extra. My lord,
Extra
any day, my
means
lord,
what?
kindly fix up any day. So I do not want to
You
trouble
will
your lordship.
stand your hands.
Any day, my lord. Any day, my lord. Before Tuesday, my lord, I can come back. I am ready with this. If my lord allows, I can submit
Your other side is there.
My lord, all parties are.
Mr. Kankani,
My lord,
till tomorrow, don't take it. The regular bench will be there. Why do you demolish it?
My lord, only one thing, I will point it out to your lordship, my lord, there's an order of the coordinate bench to demolish in the proceedings under 226. The petitioner therein had filed a writ petition.
No, not
in
writ
that,
petition.
my lord, not
Private respondent had filed a writ
no, the writ
petition
petition is there, I'm
saying,
saying. My lord,
may I just
my lord, in
explain
that
the situation,
matter,
my lord?
in that matter, there's an order, hearing was
Yes.
given to them.
Yes.
There is no
Order
sanction
impugned.
plan.
No,
Today
no, no.
was
There
fixed
is a
for-
sanction plan.
Today was fixed for demolition, my lord.
Order impugned.
They get the order 2 months back. 3 days ago.
Very well. For 1 day, nothing. I am not the regular bench. For 1 day, if you defer it, what will happen? What will happen if
My
you
lord,
defer it
in that case, my lord, because the only difficulty is there's an order of.
where is the order of the?
My lord, may I hand over, my lord, this order?
My lord, may I just indicate the order? May I just
Just a
indicate?
moment.
Because this is not in the same
Let
proceeding.
me see. I'm not hearing
My
it.
lord, it is not part of the record. That's why I'm indicating. My lord, because my lord, that is not the. Kindly allows me, my lord.
Oh,
My lord, may I hand over the impugned order, my lord?
my lord, your
May I
lordship,
hand over?
First, the order of the coordinate bench.
Yes,
this one.
kindly.
The soft copy. Lordship will kindly see the last paragraph. And we have to file a compliance report. And on our submission, on the last date of hearing, that we are going to take demolition steps on 31st. Lordship will kindly see the last paragraph my lord, of this. And we are supposed to file a report with the registrar.
So it is within a period of 6 weeks. You have time. You have time.
Madam, because we have time.
Mr. Kankani, be reasonable. 6 weeks you have time. It is in accordance with law. In accordance with law, they are also entitled to challenge the demolition order. You cannot pass the order today.
My lord, they have challenged the order and the municipal building tribunal has dismissed.
Against the tribunal also they have a remedy here.
Yes.
Now to let them have it before the regular bench, I'll just postpone it. For I'm not directing you to stay your hands forever. Just postpone it till the regular bench comes and tomorrow the regular bench will be there.
Only
if you are
limited.
willing, you can come tomorrow and argue.
Yes,
I'll fix it tomorrow.
Tomorrow.
Tomorrow it is.
Bas. Tomorrow you
Very
will
well. I'll do it tomorrow.
Well, tomorrow.
No, I'll do it
Tomorrow.
Do it tomorrow.
I'll do it tomorrow, my lord.
Do it tomorrow.
Yes.
Till tomorrow, please postpone.
Yes. Your lordship will
Kindly make it till
The hearing before the commissioner, I was present in all the hearings before the commissioner. They have.
This report says,
Lordship kindly sees the order of the commissioner once, Lordship. The
order
attendance-
of the commissioner is being challenged on the basis of this report of the commissioner executive engineer.
Lordship kindly come
So
to
this
the-
is enough for today. You go and argue before the regular court unnecessarily with. Enough. চলুন অরিজিনাল থ্রেড কল করে দিন ও অ্যাপস এক্সটেনশন গুলো কল করুন
My lord, I am for the petitioner led by Ms. Sebjani Sengupta, Lordship. Interim order will be expired on tomorrow, Lordship. Kindly extend the order.
Opposite party, my lord.
Having heard the learned advocates appearing for the respective parties, the interim order granted earlier stands extended till the end of August 2026 or list this matter টা না কেটে দিন liberty to mention করে next
27 Lordship interim order till today.
learned advocate appearing having heard
My lord, I appear for the applicant. Interim order is in force till today, lordship.
same order till the end of August liberty to mention
And deeply
Well, 79 minutes, I appear for the opposite particulars. I have a very innocuous prayer. 79 minutes.
78-9 has not been called.
I'm sorry.
I am for the petitioner. Order still enforcing today. Kindly extend.
I'm extending the interim order for a
No
limited
problem. No problem. But there is one problem because your lordship had extensively heard the matter on 11th of May and 22nd of June. Let's kindly makes it part heard. Let's takes it up. Let's kindly minutes.
Kindly extend, my
no.
Because your lordship had heard the matter.
Having heard the learned advocates appearing for the respective parties, comma, the interim order granted earlier is extended till the end of August 2026 or until further orders, whichever is earlier. Liberty to mention.
Much
Next.
Well, the interim order expired. Your lordship had extended the order which till end July 26, and matter was to appear before your lordship. Then, my lord.
Sima, having heard Mr. Bose, you are appearing for the other side? No, you're there.
So I'll file it on the next.
ওনার নাম লিখে নেবেন Miss such and such appears and undertakes to file wakalatnama on behalf of the opposite party. Appearing for the petitioner and Miss such and such learned advocate appearing for the opposite party. The interim order granted earlier is extended till the end of August 2026 or until further orders, whichever is earlier. Liberty to mention.
The lordship is not directing the matter to appear.
Because I can only direct subject to his lordship's convenience.
My lord, I am appearing on behalf of the petitioner. The interim order is enforced till today.
Order. Opposite party?
Opposite party.
We having heard the learned advocate appearing for the petitioner and having considered the material on record, comma, the interim order granted earlier is extended till the end of August 2026 or until further orders, whichever is earlier. List in the
The opposite party. Mr. Anand.
none appears for the petitioner. Let this matter go out of list. Next.
Lord, I'm for the petitioner. The interim order is enforced today, Lord.
We having heard respective parties, August, liberty to mention.
Grateful, my lord.
Okay, sir.
My lord, I am for the petitioner. My lord, it's been forced till today, my lord.
Extended
Both-
till the end of August, liberty to mention.
84 and
End of
85
August.
are similar matters.
Huh?
my lord. End of August.
End of August.
My lord, 85 is a similar matter.
Let it be called.
My lord, 85 also similar? Similar matter.
Same order. 85 of the nil,
Deeply obliged.
I'm appearing on behalf of the OP. Today the interim order is expiring, Lord. Now we have given the notice to the other side.
But I appear for the opposite party in this matter.
I'm for the OP. It's appearing for the respective parties. The interim order granted stands extended till the end of August 2026 or until further orders, whichever is earlier, liberty to mention.
Yes.
Get lots, much of us.
Next.
My lord, the interim order is expiring today.
Lord, my execution has been stayed, my lord, nearly for a year. Limited time, my lord, it may be extended. Not for a month.
Having heard the learned advocates appearing for the respective parties.
Lord, kindly,
He'll
He'll be there tomorrow.
Grateful, my lord.
17th. Till 17th it is there.
Grateful.
I'm happy. The petitioner.
This matter, my lord, extensively heard by your lordship. Your lordship, can you recall, my lord, Mr. Rai and me appeared. The first question arose, my lord, whether pendency of the review application, my lord. Kindly mark it. My learned friend will also not oppose, I think, my lord.
Of the opposite respective parties, the interim order.
You heard the matter, my lord, extensively, my lord.
Number 89, I'm led by Mr. Bakshi. He will be
My lord,
appearing in actual mode.
my lord, I beg to appear, my lord, in this matter, my lord, for the private opposite parties, my lord. My lord, in this matter, my lord, I would humbly beseech your lordship, my lord, not to extend the interim order. My lord, we can argue this matter on merits, my lord.
The regular bench will be
My
there.
lord,
I'll only extend it for 10-15 days. Go and mention it.
may I just kindly say, my lord,
Mr. Bakshi, at this stage, I'm not going to hear
nothing,
it.
just kindly, only one thing, let me submit one thing, madam. What I would humbly beseech your lordship, to extend the interim order for a period of 7 days, and then to fix a date for hearing, kindly, because it involves, a senior citizen matter, the deed was cancelled.
I can also prove, my lord. Yes, my lord. Your lordship has already heard, my lord.
Advocates appearing for the respective parties. The interim order granted earlier is extended till August 10, 2026 or until further orders, whichever is earlier, liberty to mention.
My lord, may I say this, my lord, kindly fix a date for hearing, my lord, kindly fixes a date for hearing.
I don't have the regular determination, Mr. Bakshi.
My lord.
No, August 10, my lord. Your lordship has
My lord,
extended.
the interim order is extended till the 10th of August, my lord.
10th August, yes.
My lord, I'm deeply obliged, madam. I'm deeply obliged.
Yes.
And my lord, I am for the petition. I am for the opposite party, my lord.
I'm extending it. Having heard the learned advocates appearing for the opposite party.
Yes. Unconditional apology. A mistake has been done from my end, my lord. Probably in hurry, my lord, the instruction, he did not understand my client, my lord. The land has been acquired. But the
I said so. Then
so,
let
my lord,
that
kindly
case.
clarify that order, my lord, kindly, that order which has been
The
recorded.
steno has also gone. Everybody has gone.
Oh.
It will appear on Monday. I'll recall that order. It will appear again on Monday.
And my lord, at 10:30. I humbly beseech your lordship to kindly allow me to make some submission, my lord.
Please don't waste because Monday will be monthly list day. Please stay your hands. Why don't you use your good offices?
No, I'm saying,
Why
any day, lordship fixes, any day. I'm not seeking on Monday.
Because if you go on pressing unnecessarily for something which you have done wrong, unnecessarily, how will the court function?
I do not protest. Any day, my lord.
So Monday will come back.
If he is not in possession, you are in possession. Why are you asking him to pay money? This is unjust enrichment on your part then. You can't have best of both the worlds. You will have the land, you will have the money, both. That can't be. It was wrong on his part to seek revision.
Yes.
That I am against. That you have discarded, rejected. Very well, you are entitled. But the other step that you took, saying that no, you have to refund, get it corrected, where is that authority? That's not there. You
But
cannot
that,
do it.
no, that's the only thing because that has been paid to them.
Paid to them for money, for
the
the land. You are there in the having the land.
I'll come back.
ওই ওটা
I'll come back.
ওনার ওই যে একটা ম্যাটার হলো না একটা
23
ওটা ওই অর্ডারটা রিকল করতে বলে দেবেন, ওই অর্ডারটা ছাপবে না, সোমবারে থাকবে, কারণ ওই 23-এর আপনি নিয়েছেন, উনি নেননি না, উনি নেননি, আপনি দেখে বলে দেবেন ওই অর্ডারটা ছাপবে না, ওটা লিস্টে সোমবারে দিয়ে দেবেন। হ্যাঁ, আচ্ছা, অ্যাসাইন ম্যাটার হিসেবেই থাকবে, অ্যাসাইন ম্যাটার হিসেবেই it will appear as an assigned matter only.
So, my lord, liberty may be given to draw your lordship condition.
This is definitely always there. Both sides, if you come and mention, I'll take it up at 2 p.m. if I don't reach in usual.
Extremely sorry for the inconvenience.
No, not at
Kindly
all.
pardon. Great.
Outer not today. 23 I have marked not today. I have marked it not today.
The original side.
But in the original side, may I have a lordship sleep to mention a matter for inclusion? Testamentary matter and non-contentious testamentary.
Testamentaries are coming.
These are old, 2025. Great.
Did I appear for the
I appear for the defense.
A1 is my application under order 12 rule 6. This was Millard for goods sold and delivered, and Millard the money due on account of Millard the goods. Millard goods means Millard the service provided. I am Millard a transporter. Now, my lord, kindly come to page 28 to 37. Are Millard the work orders? Millard, initially, Millard, I was enjoying an interim order. I am enjoying still, but Millard, that has been modified by your lordship subsequently. My lord, recollect, Millard, the injunction was that Millard, they will not be allowed to set apart the admitted amount from their account. Subsequently, it was passed by Justice Rai. Millard, subsequently, when it was assigned to your lordship, Millard, it was discovered that Millard, they had Millard dissolved those bank accounts, those are no more there. So my lord had accordingly Millard passed the same order on the bank accounts furnished by them. Now Millard, now it's coming for the final hearing. Now Millard, from page 28 to 37 are the Millard the work orders. Is the emails. Now Millard will kindly come. Millard, page 38 to 51 are the invoices raised.
Page
38 to 51.
Yes.
Page 53. Millard, a check was handed over.
28 to 37 was what?
Work orders.
And 38 to 51.
30 to 51 are the invoices raised. Then Millard kindly comes to 52 immediately thereafter. Millard, this is their letter. PIL Limited written to JCC Private Limited. Kindly mark the date because this is going to be very crucial. 16th March 2022. And by this letter, kindly see what they have written. Post-dated checks against your payable dues. Now, Millet, kindly see, please, they have written, please refer to the communication we had on the subject. We have agreed to make the payment to you against your payable dues as per the mutually agreed plan. Accordingly, we are releasing you the post-dated checks. Millet, there are 5 post-dated checks. First amount was 15 lakhs. Then, Millet, all are of equal, Millet, installments or equal amount of 10 lakhs each. Now, Millet, first, Millet, kindly comes to page 53. Millet, I should clarify, 15 lakhs was subsequently paid by RTG, bank transfer. So, Millet, I returned the check. 15 lakhs paid by bank transfer. Now, Millet, from serial number 2 to 5, I deposited the first check when the date came. Kindly comes to page 53. First check of rupees 10 lakhs. Millet, kindly turn the page to 54.
Yes.
This is the dishonor memo issued by the Droy Bank dishonoring the check. 10 lakhs dishonored. Millet, I have pleaded in my petition. Millet, immediately thereafter, I had drawn up, Millet, a proceeding under section 138. Kindly takes page 55. This is the notice issued under section 138.
Page 55.
55, yes. For the 10 lakhs only. First check.
Yes.
Now, Millet, thereafter, kindly comes to page 63 because thereafter all the delivery challans and AD acknowledgement due cards are there. Kindly comes to page 63. I had to file a 138 proceeding.
63.
63. My lord will find the type copy at page 63, capital A. Well, this is an order passed by the 11th Metropolitan Magistrate Court, where, Millet, they had settled the amount, paid off me the 10 lakhs, matter got settled. Now, Millet, again, Millet, recollects page 55, page 52. So, out of 5 checks, 15 lakhs paid by bank transfer, 10 lakhs paid after the proceeding. So, 2 checks gone. So, there are remaining 30 lakhs. My lord will kindly see.
Just a moment.
Kindly see page 52. Kindly,
where was that 15 lakh paid?
15 lakhs paid, Millet, I have made an amendment in my body of the petition paid by bank transfer.
That's
Yes.
not under you.
Yes, not a part of this.
Very good.
So, Millet, 15 lakhs paid by bank transfer, 10 lakhs paid after the proceeding.
So, this 30 lakh is the
30
subject
lakhs is the
matter of this.
principal. Yes. Kindly see page 65.
Yes.
Millet, this is the third check. Dishonored, page 67. Page 67. Kindly see page 68. Fourth check.
Yes.
69, Millet, the memo raised by the Droy Bank, dishonored. 69. Then, Millet, page 75th check. Millet, dishonored, page 71. Then, Millet, I need not bother lordship. This is the, Millet, conciliation proceeding that had gone. They had not attended. So, Millet, it failed in the non-starter report at page 83. Then, Millet, I have annexed the plaint. Millet, these are on, Millet, facts. Now, Millet, today there are at least 4 documents, page 52, there later, admitting their claim. Out of 55 lakh, 25 lakh paid. I am, Millet, before a lordship of 30. Now, Millet, order 12, rule 6. My lord is, Millet, aware, Millet. And, Millet, may I CPC Act of copy?
Yes.
Yes. Let order 12 rule 6 says, where admissions of fact have been made either in the pleading or otherwise, whether orally or in writing, the court may at any stage of the suit, either on the application of any party or of its own motion, and without waiting for the determination of any other question between the parties, make such order or give such judgment as it may think fit, having regard to such admission. So, there are judgments at galore, starting from Google and latest in May 2026
party walas.
Yes, yes, scope is very wide. Even an admission in Uttam Singh Dugar, the admission was made in of the meeting of the directors. From that admission was granted. Till 2026, issue is the same 2G. In a written statement, they had made the admission. So that was granted. And it has been held, quote unquote, the word otherwise. It gives a wide power to the court. Of course, this is not at all mandatory. I should be candid to your lordship. This is lordship discretion. Now, coming back, it is my duty to show their defense also. Now, kindly takes up their opposition.
Their opposition is.
Their opposition, they runs up to 4 volumes.
4 times your
yes,
position.
Yes.
So they have a robust defense.
For 4 volumes, I'll only take page 283, volume 2. They say that they have made me payments. I say that this was not my transaction with them, solitary transaction. I had been working with them. I had been providing my logistical services with them for some time. There are other work orders, and this is a separate work order. Now, they are trying to intermingle between all the work orders. My lord, the proceeding before your lordship is only with reference to the work orders which are the subject matter of the proceeding. Now, for a moment, kindly takes volume 2, page 283, annexure B. Because the volume A is there, the balance sheet and audited, those are there. So kindly takes page 283. Now, in 283, they have given a schedule of the payments made. Now, kindly, for why I said when I started off that 16th March 2022 is the important date where they had handed over me the check, 5-dated check. From this, my lord will now understand, will appreciate that why so. Kindly see the transaction dates. I think it's 6-4 or 8-4. Maybe, be that as it may. First is 8th of April 2021. Second one is 14th of April 2021. Third one is 14th of July 2021. Fifth one is 17th of February 2022. Thereafter 18th of February 2022. And the last one is 21st March 2022. The PDCs, the post-date lecture were all subsequent to these dates. Even if for a moment my lord takes up their case, that falls flat on the face because you have issued the post-dated checks, dates were written, those are all subsequent to these dates. Because the first letter through which they the forwarding letter is itself is 16th March 2022. And the PTC starts from 30th April 2022. Those are all subsequent to these dates. So you have issued the PTCs taking in consideration this, your ledger. Of course, there would have been a doubt may have arisen in my lord's mind if my dates would have within this period. The PDCs are all beyond this date.
And after this date, you did not enter into any other transaction?
No. As of that, no. So if this is subsequent, the PDCs are subsequent, then it is presumed that you have taken care of these payments. and you have issued the PDC. And your version in the letter of 16 March is very clear, unambiguous, transparent, and there is no ambiguity that amount payable to you. And to my understanding, this requires no adjudication on trial.
There is a provision in Contract Act that if payments are made without disclosing for what the payments are to be, against which dues the payment is to be adjusted, a particular payment, then they will be adjusted chronologically. The first one will be squared off by the payment.
I'll look into Millard. Millard, I have enclosed the prior work orders also.
আমাদের কাছে কন্ট্রাক্ট অ্যাক্ট আছে, কন্ট্রাক্ট অ্যাক্ট আছে, কন্ট্রাক্ট অ্যাক্ট, ইন্ডিয়ান কন্ট্রাক্ট এখানে নেই, এখানে নেই, কোনোদিন দরকার পড়েনি বলে আনা হয়।
I have not.
Very interesting act, contract. Very interesting provisions are there.
I'll get Millard from Balaji. Nearest.
It has saved me in many matters.
Yes, yes.
I am not being able to absolutely recall it, whether it will be applicable. Yes, I've got it. Section 59 and 60.
59 and 60.
May not be relevant, but I don't.
I'll definitely look Millard. Let him come Millard with the.
এটা দিয়ে দিন।
Millard, 59, 60, where the date is not indicated, where the data is omitted to
indicate again as against which.
So I can
therefore
adjust
you
it.
can adjust it against the first.
Against
due.
the first. I'm grateful, Millard. So Millard. So Millard, I will restrict myself to the Millard Arena Order 12 Rule 6. Millard, now Millard, the additional case made out by them is that there has been a change of management in the meantime. And we are unaware of any letter being issued by any employee of the earlier management. So Millard, to that Millard, my contention that's Millard not at all Millard cannot be a Millard way to get out of Millard the admission made by you. Millard, they say there has been a change of management. So the new management is unaware of Millard the letter issued by the erstwhile management. Millard, that's not my lookout. Millard, request of respect to my learned friend. Number 3, the third point is raised by them that they are going through a severe, stringent financial issues. So they were not in a position to pay, and for that reason there has been a change of management. And of course, for COVID-19, they have taken the issues. And be that as it may, that does not give away Millard the admission made by them.
Mr. Dasgupta, what is your stand? You are not required to pay or
there's nothing due and payable. So I've paid, Millard. I'll show it in my affidavit.
The judgments, I'll show his affidavits. Now, Millard kindly takes his affidavit once, Millard, the first volume.
First volume, yes.
Yes. Now, Milord, kindly see Milord para 13, page 5. The first point that I indicated to your lordship.
Yes, precarious situation.
Yes. Milord, the second Milord issue is Milord para 15, page 6. Taking over. Milord, the third issue is Milord para 16. There has been OTS settlement reached between the consortium. Milord, be that as it may, I am not concerned with this. They have been
The change in management was because of CIRP.
No. Usual.
Not a CRP.
Not a CRP.
Normal.
Usual. They say it was in debt. So the earlier management could not Milord run it properly. So there has been a change of management. Now, Milord, kindly see para 17.
No, 16 mentions about
16 haircut. Milord 35% haircut. So Milord initially Milord
So haircut without CIRP. What kind of haircut?
no, the management has taken over. What?
The management took over and the new management offered a haircut to the creditors. Now, the stated on instructions, what we have stated is most of the creditors have accepted the haircut and they have accepted the payments. Save and accept the.
I should be frank, Milord, before coming to your lordship's court, they had also offered me to settle with same 35% haircut. But Milord, my clients could not accept that, Milord, because it was during the continuance of the suit before Justice Rai, Milord, they had come. I think those are recorded also, Milord, in the orders passed by Justice.
আগের order গুলো একটু দেবেন?
এই আগের অর্ডারটা দিয়ে একবার প্রথম দিকে যে সেটেলমেন্ট হ্যাঁ অনিরুদ্ধ রায়ের অর্ডার সামনের দিকে থাকবে না এই যে সেটেলমেন্ট এই দেখতে পাচ্ছি Milord, kindly see it is July 16, 2025.
July?
Yes, July 16, 2025. Oh, before Justice Rao.
July 16 order.
You
have a copy of the order?
Yes, Milord. Well, I am handing over the bunch, Milord. We have taken adjournments also on this. Kindly see this order and order prior to that also, Milord. The matter could have been settled. Any decent amount. The amount is very less. 30 lakhs of today's date. Milord, the matter could have been settled very well. The reduction they had.
Can we settle now?
I am open.
But I have been taken, although my submission was that there is nothing due and payable, but the amount that they are claiming the suit, that is 30 lakhs, which I can, on the record, I can show that that amount is not due and payable. It is a very small amount, meager.
Why were checks issued then?
Checks were issued under various circumstances because before issuance of checks, which the plaintiff did not plead in the plain or in the application, which we disclosed in our affidavit. But as per the pleading made in the application, 55 lakhs was due and payable. Then 25 lakhs was paid off by us. 55 lakhs was due and payable after adjusting all ad hoc payments. Let my learner. I'll still take instruction whether any amount can be proposed by us.
Why we intended
to
yes,
no,
because why we
we
intended
were
settlement, it was only 30 lakhs. Any decent
There
amount.
is, I understand.
With the suit progressing,
the 30 lakh parties will lose.
That will vanish and something else will again come out after
Yes.
that.
My learned senior friend, fees will be much more than.
No.
I'll take instruction.
So Milord, the 18th is also Milord same, Milord new promoters. Now Milord para 26, page 9. They say that until and unless the notice was served along with the plaint and the application, they were unaware of the date. Page 9, para 26. And Milord, at page 11, they disclose for the first time before your lordship, Milord, pursuant to your lordship's order, 3 new bank accounts where my lord had passed an order. only Milad, only one thing.
তখন জানতে পেরেছি এটা পাওয়ার আগে, কিন্তু আমি যখন 130 প্রসিডিংস চিঠিটা সার্ভিস
হ্যাঁ।
করেছিলাম তখন আমি 16 মান্থের এটা বলেছিলাম যে 5টা ডিউ আছে, তাহলে আগে থেকে
হ্যাঁ,
জানতো আমার।
if Milad takes page 57 once of the
my
petition, GA1, Milad, they are stand in paragraph 26, Milad had seen that they are coming across of this due only page 57, yes, 57. This is a part of Milad, the 138 notice. Milad, where
57 of your petition.
of the petition GA1,
Yes.
where Milad, in my notice, I had specifically mentioned about, kindly see page 57.
Yes.
Second line. After repeated follow-ups and precautions and demands being made by the client under cover of your letter date 16 March 2022, Milad, entire issue has been Milad narrated to them. This letter is dated page 55, 31st May 2022. So this stand taken by them in paragraph 26, Milad falls flat, that come across the date.
They acknowledge this letter.
138 proceeding filed, they got settled the matter. I showed page 63. This culminated into 138.
So this 138.
Yes, this is
settled upon
they
their-
settled, yes. Upon payment of 10 lakhs, yes.
Upon the new management taking over.
No, this is with regard to the old management.
Oh, that is why I said that
This is with regard to the old management. So Milad, this is not a Milad, a sole solitary Milad, that issue of 15 lakhs or 10 lakhs. They had settled the amount. So the new management coming across for the first time will not Milad make any change to this.
আমরা তো এটাও সার্ভিস করেছিলাম, এটাও তো আমরা জানবো কনসিলিয়েশনটা, কনসিলিয়েশনটাও তো সার্ভিস করেছিলাম সেটা
Conciliation also fine. Now Milad, they also deny that they have received the mediation center's notice, but there is no change in the address. They have denied everything, random. Whatever coming on their way, denied. So Milad, I have not sent the notice. The mediation center has sent.
That is usual. We all deny that. In pleadings, you
No,
have to.
random Milad. Milad, day before yesterday.
That is the safest.
Milad, day before yesterday in a commission, my witness was saying, what is your name? What is your father's name? Other side objected. I said, what are you doing? No, objection. And Milad, the commissioner initially was trying to pacify him down because commissioner doesn't have much power. But ultimately, she had to take a stand and no, your objection will not go.
Problem is in flat denials when you deny something which
yes. The client is saying my father's name is such and such. He said I'm objecting to it. What to which level of objection can go? Let me come back any day.
When?
Any day. Any day.
Next Friday. Next Friday.
Next Friday, I'll take about 2 p.m.
Yes, 2 p.m. or 3 p.m. whatever it is, because I don't think next Friday we'll have those original side. I mean the appellate side urgent matters. Will
yes,
not be there.
that will
Because
not
of
be.
these 2 weeks.
Yes,
These 2
because of
weeks
the
were-
urgent determination, that was
Yes.
chaos.
No, Milad, kindly keep it at 2 p.m. Milad takes it up because Milad
Original side 2 p.m.
2
Original
p.m.
side is usually, it
2
won't
p.m.
be in the first.
No,
half.
sometimes Milad that takes up 12 p.m. Then Milad.
No.
2 p.m.
That was when I had division benches then.
Justice Banerjee.
Yes, because if the second half, if I have division bench, then original side will not be touched. So I.
Yes.
Very good. 7th.
7th কিছু আছে মানে ফিক্সড কিছু নেই তো? হ্যাঁ, ফিক্স নেই তো? ফিক্সড আছে? সুবিধা নেই, এটা তো উপরে চলে আসে। তারপরে হবে 3 p.m. Whenever the original side is taken, it may be 3 p.m. instead of 2 p.m.
And kindly retain its position, Milad, then I
Yes,
can
it's
conclude.
commercial
Yes.
matter, so it will retain its position. লিখে নিন।
my lord, I have indicated to him, my lord, that to keep it at 2 p.m. first half we have trial courts. Even if my lord,
We won't have it in the first half. In any case, we'll have appellate side at the
yes,
first
yes,
half.
yes. Anything, my lord, we are getting prejudice tomorrow.